May I mention one matter for inclusion in the release for modification?
Application.
Milord, may I be permitted to mention a matter, Milord? This is an
I have Milord, kindly Milord, to mention this matter. Milord, stream urgency, it's a covered matter essentially. It's a covered matter by a judgment of our court. Difficulty, Milord, Milord, the petitioner is suffering from cancer. And Milord, this is an application which we have filed. I'll be candid with your Lordship, Milord. This application is essentially for Milord, the expeditious hearing of the matter. It's a covered matter, Milord. Will not take more than 10 minutes.
What is the issue?
Milord, the issue is that the charge sheet has been issued upon direction of this honorable court, Milord, without following any procedure. Where the first round of litigation we had challenged.
Disciplinary proceeding.
I mean, may I only indicate this? The first round of litigation, Milord, we had shown how egregiously, Milord, they had performed the other side, Milord.
Disciplinary proceeding, how can it come before this court?
Milord,
it's a
municipality, it's a municipality matter.
He was in
Municipality, I do not have.
Bhatpara municipality, he was.
I do not have determination with regard to Group 5 municipality. Yes, call the list.
Then may it be listed and then may it be, Milord.
Why? I do not have determination.
File is with this honorable court. Well, file is in the honorable court, Milord, I'm told. Milord, then it has to be
listed.
It is, Milord, it is not listed,
It is appearing in the.
but it is appearing in the monthly list, I believe, the main matter, Milord, the writ petition.
How it has come up your instant mentioning?
We had mentioned this before, Milord.
What is the item number?
Milord,
Do we
it's-
mention the Koredin Kalke?
Milord, very deeply obliged.
Do we mention?
Item number.
It will indicate the item number also. Deeply obliged.
Yes, call the list.
Item number 5, Mr. Lanet, Advocate Joydeep Kosi, he's on the way. Can it be passed over? He's on the way.
On the last occasion, officer directed us to take instructions so far as any settlement can be arrived at. So mine,
I was told that the settlement has already been arrived
no,
at.
it
Only for a written instructions I have kept it.
no, the instruction.
Not arrived at.
So far as WBIIDC is concerned, there was no settlement.
Lord, can I just point out, Lord, perhaps, Lord, it will come back to my Lord's mind that my learned friend's client had forwarded the deed of assignment for execution. Now, Lord, this document,
But he is saying that there is no consensus.
Lord, I can show from the writ petition itself. It's his forwarding letter saying this is the document which has to be executed. And that assignment
And
will
you have
to
called for a hearing. You have called both of them.
Because
Mr.
of
Court's
the-
client and the.
Because of there was a direction by this honorable court.
But where is your decision? You have also not taken it, communicated the decision. You should have communicated your decision. You called for a hearing. They participated. So, if according to you, it has to be rejected, you have to pass an order. How can you keep that matter pending for a long time?
Well, no,
Have you
whether
communicated your decision of the hearing?
no decision has been communicated.
Why?
Lord, we are, Lord,
The
going to
termination was not only there are several grounds for termination. The major two grounds were non-utilization of the land for several years because that was the main.
The court, it is to be now, they are not on consent.
then Lord, place it for hearing, because I thought, Lord, this document they had forwarded saying that we will not execute this deed of assignment. IFCI should.
On the other day, the learned advocate who appeared, he did not say anything. He also orally submitted, yes, we are agreeable.
Correct.
But I wanted a written instructions for that. I kept it.
Perhaps that
Otherwise,
was
your learned, your junior would be in difficulty.
no, that
That
was
recorded on the basis of his submission.
no, that was on the. I believe that was
No,
the
no.
submission of the IFCI, the other respondent.
Sir, he has produced, he or she has produced the email.
That
I've recorded that. For,
No, that was
IFCI.
IFCI.
That's for IFCI.
Yes.
But for you, your learned advocate said, yes, there is a consensus. Please see the order. That is why the learned advocate, please see page 2,
Yes.
penultimate paragraph. I have recorded the submission. Representing the WBIADC 6 time to place on record the written instructions from our client.
Yes, she did not have any instructions as on that day.
Said that there was a consensus. Only I wanted that written instructions, for that I have recorded.
Lord,
I have got the
Otherwise,
written-
I could have.
after
this
much
one-
difficulty, we have been able to persuade IFCI because, WBIIDC, they said that we will not execute the document because the mortgage right was
Now,
executed.
Mr. Court, there are two ways of looking at it. Maybe some communication gap, I do not know. if you can impress upon your learner so that he can take instructions in that line, or I have to keep it for hearing. If there is no consensus, Mr. Kaur, it has to be a judicial order. I have to decide it on merits then.
Madam, based on losses, I have taken written instructions from my client. We have instructions to contest. There is
Then Lord, place it for hearing because I thought Lord, it was their proposal that get the
Thank God
assignment.
I was about to dispose of on that day itself, 7th.
I also thought Lord, there was a
Yes.
complete consensus.
Who appeared? Amit Kumar Nag. Who
no, no,
appeared?
my junior appeared. I'm Amit Kumar Nag. Rishita was there.
Miss
Sarkar.
Rishita Sarkar. Where is she? She submitted yes.
There was no instructions on that.
And you did not appear and your name has been recorded now. See, your submission, it goes with
Lord,
your submission
it
now.
hinges Lord, on a very, very small point that Lord, without a deed of assignment, whether it was possible for us to commence Lord, our
I
business.
appreciate
I
that,
have
but
purchased
Mr.
Lord, in
Kaur,
a
I
surface
have not heard this matter earlier.
I know.
So I will
I
have
know.
to hear it for the first time.
Kindly, Lord, if it is possible, kindly, Lord, accommodate us on any day convenient to your Lordship. Lord, any day convenient to. The only point is that without the deed of assignment, whether it was possible for us to commence our business.
Today, when this matter is taken,
After all, Lord, this is an industrial plot. Much okay.
7th of monthly is not 7th of May motion. Yes, call the next matter.
But there's one correction, Lord.
What is the application for Mr. Kaur?
Application is, Lord, for direction of registration of the deed in terms of the settlement.
That's the main relief claimed in the writ petition also.
I thought if the settlement, Lord, goes through, then, Lord, your Lordship need not, Lord, get into the matter. But anyway, that
The application is
application,
to be kept pending then.
they take it up along with the main writ.
The application to be heard along with the writ petition.
Lord, there is small correction in the order. Lord, in the cause title, Mr. Nag's appearance is shown for WBIDC. It should be II.
IIDC. এই ওই আগের দিনের অর্ডারটা
I'm really sorry, but just struck me.
এইটা না it has been pointed out এটা একদম উপরে করে Yes, Mr. Chatterjee.
No, my lord, in this matter,
That matter,
earlier writ petition was filed before this
you
honorable
want to
court.
file a supplementary affidavit?
No, my lord, they have filed a supplementary affidavit over and above my affidavit in reply because I have indicated certain issues. In the supplementary affidavit, they have
You
taken
have taken fresh points in the reply.
the point that the writ petition is barred by constructive res judicata, section 11 of the Civil Procedure Code. Then I have checked out how it is correct. Then I have seen it that to some extent Mr. Pan's point is correct. But before the Honorable Supreme Court, Article 32 petition was moved after entire thing was done by the Honorable Supreme Court sometimes 10 years back, 10 years or 15 years back. There, before the Honorable Supreme Court, the report filed by the judicial officer as appointed by the Honorable Supreme Court was under challenge. There, the liberty was taken from the Honorable Supreme Court that this Article 32 application petition is not pressed with the liberty to move before the Judicial High Court with the self-same relief. And the Honorable Supreme Court has granted that. Liberty has been granted. Accordingly, the writ petition has been filed. Unfortunately, while drafting the petition, that portion, that the that prayer of the Honorable Supreme Court before the Honorable...
Order of the Honorable Supreme Court in Article 32 petition was not.
No. Article 32 petition's order was there. But the prayer indicated in Article 32 petition challenge.
According to you, that might be relevant for deciding the issue of.
That's right.
Of res
Otherwise, res judicata, I shall hit by res judicata.
So according to you, because of the liberty granted by the Honorable Supreme Court to enable you to move before the jurisdictional high court on the self-same cause of action. So according to you, the prayer which you made before the Honorable Supreme Court that you can make here.
I can do two things. I can amend the writ petition by incorporating the prayers, only the prayer portion, or I can take liberty from your lordship to move a fresh writ petition challenging with this. I
Move a,
fresh writ petition by incorporating this fresh prayer and fresh
I think
whatever.
Mr.
And
Pan, you are opposed
My lord,
to
I have
this.
I have a very strong
one
objection on this.
Mr. Pan, I am not deciding any
No.
issue.
I have a very strong objection on this, my lord, on this twofold ground. Because my learned friend, senior friend just said that he intend to challenge the report filed by the judicial magistrate in terms of the order of the Honorable Supreme Court. While considering that order, Honorable Supreme Court categorically stated, this order attained finally, no one can challenge this.
All right, I'm
Uh,
not entering into that.
Yes, my lord,
now.
no one can challenge this.
Yes.
Now, my lord, admitting that position, what is the issue involved before your lordship? Issue is implementation of the scheme of employment floated by the ECL.
Employment is in
Against
name of acquisition.
Acquisition. My lord, now fact remains that altogether so many people approached before the Supreme Court. Now, out of which report says only 20% found eligible. Now the petitioners
Persons.
only 20%, and that has been accepted by the.
Petitioner is not within.
Now,
that.
my lord, yes, the petitioners, some of the petitioners before your lordship, they were nominated by
The others.
others. That is my point, specific point. Let me
No, they
taken
are
in this
taken.
meeting.
Mr. Pan, those are on facts. I
Yes.
will decide that. I will keep
So-
your objections open.
Now, my lord, what I am on is this: let them amend the writ petition. Otherwise, my lord, I tell your lordship, it will be another issue is required to be opened.
Very well.
Because let them amend the writ petition. Let them amend the writ petition and the pair.
Only that will delay this
But
procedure.
I tell your lordship, they can amend very well within a day or two. Within a day or two. I tell your lordship, I will file my objection within 2 days to that. Because I tell your lordship, my lord, the issue involved, that is my categorical case. The issue involved whatever in the way, attend the finality.
Then
I can demonstrate
then
from the
what
order
is
itself.
What is the meaning of the liberty granted by the Honorable Supreme
My lord,
Court?
that is
And
Mr. Chatterjee, please show me your
yes,
writ petition prayer.
yes.
in this before your lordship,
Hey,
this is volume 1. Right?
Because you want to amend that writ petition.
Yes.
Yes.
So please show me the scope of the writ petition once.
Yes, your lordship kindly come to page 22 of the writ
Hmm?
petition.
Page
কি
20.
দেখাচ্ছিস তোরা এটা কি 131 of what? তো এটা আমাকে কি দিয়েছিস? No.
By way of amendment, because here the scope is effectively prayer B is your effective prayer.
Yes.
Other is to produce the records and other things.
Yes.
So you wanted directing them to give you employment as per the policy of that rehabilitation and resettlement. So that's your effective prayer here. So prayer you are not changing because that's your prayer. Now
No. Before the Honorable Supreme Court, that was my prayer. I have
was your prayer?
challenged.
Please show me the what
Yes.
was before the Honorable Supreme Court.
It was everything. Yes.
For quashing the report
Yes.
of the DM.
Because in that report, exception to that report, the point was categorically taken that no opportunity of hearing was given, no notice was given. But unfortunately, that could not be placed or that was not placed.
Please show me the order of the Honorable Supreme Court under Article 32.
Until 32 years. Page,
Is it in this bunch? It is in
No.
this. No.
page 383 of the my writ petition, volume 3.
3 volumes of writ petition, Mr. Chatterjee.
But what can be done? Your Lordship's court has passed that more than 150 pages cannot be in one volume.
So writ petition of more than 150 pages.
More than 150 pages. Annexes are there. From my chamber it is originated. It may contain up to 50 pages, not beyond that.
আবার ওরে ওরা অন্য কথা
Answer
বলিস
also
তোরা
in
না
volume.
জানা
Yes.
বুঝে সুঝে বলিস তো।
Today I have received one copy of the civil division containing 6 volumes.
Page?
Page 383.
সুপ্রিম কোর্টের ফাইনাল অর্ডারটা দে।
Page 383.
কোথায়? 16তে আমরা ধরে নিয়েছি ওদেরকে থাকতে বল, নোট করতে বল, আমি আসছি। One,
So by virtue of this
one,
liberty, now you want to challenge this report of 20th of March 2013 of the district
Okay.
magistrate.
Because it was originally challenged in
part of
Article
the-
32 petition. Because at that stage, before the Honorable Supreme Court, we had filed exception to that report. But unfortunately, it has not been taken into consideration or it has not been placed at all, I shall say.
This writ petition has been filed pursuant to that liberty granted.
Yes. But unfortunately, it has not been
Say
properly
please.
couched.
First
And
time
after
comment
filing,
করাটা খুব
it has
বাজে
come to
অভ্যাস।
me. I could not have the opportunity to check it up. That's the whole difficulties for me.
Then Mr. Chatterjee, Mr. Pan might be right. You have to leave to withdraw with liberty to afresh may be a problem here.
I shall amend it. Initially, I have thought it.
You can amend that because considering this, I think Mr. Pan may
Yes, yes, I shall amend it because I have also thought it yesterday evening while studying this. If your lordship granted me fresh liberty, then it will be a difficulty for us to explain the clients as to why a fresh writ petition has to be filed.
No, that's
That-
one
that-
way of
that-
looking at it. That's
That
how you will explain your client.
that is one aspect. That is one aspect, and another aspect is this: there are difficulties in moving a fresh writ petition because that will create another spate of litigation, which I do not want.
Mr. Pan
Yes,
may
yes, yes.
be justified in raising that.
Yes, yes. I want to amend the grounds and the prayers in the writ petition. That's liberty. And you will also can see only one aspect of the matter. In their supplementary affidavit, they have. Yes. In their supplementary affidavit, your lordship can take their supplementary affidavit of Mr. Pan's supplementary affidavit. আরে দাঁড়া না বাবা আমার কলাই আছে। Yes. Since supplementary affidavit হয়েছে দিয়েছিস?
Not a supplementary.
Now filing.
Yes.
At a record করে দিন তো supplementary affidavit. You want to show?
সে মারা গেছে।
বসুন এবার দেখি।
Number here, paragraph 9
দেখে
of
দেখে।
the supplementary affidavit, they have said last 4 lines. After passing the order of the Supreme Court, Sri Ashimesh Goswami did not turn up before ECL authorities to take rehabilitation till date. The ECL authorities are always ready and willing to give rehabilitation to Sri Ashimesh Goswami in terms of the Supreme
Then
Court
what
order.
remains?
Now, number
No.
this is only one. He wants rehabilitation, and others did not get any notice to
No. This is not correct.
Animesh Goswami is
দেখি
one of
আমাকে
the petitioners.
one of the petitioner.
So his case,
না
they are ready
যেখানে
and willing to give.
Now, one difficulty is there.
রিপোর্টটা কোথায়?
By this time,
Report.
Animesh Goswami
Has
expired.
crossed the expired.
Now,
So
the
he wants
the original landowner, he has nominated another person in place of him. A fresh order is required to be passed. Because they have already accepted in principle And that may be passed at the time of consideration of that final relief or now, whatever it may be, because they have already accepted
এটা
that.
পার কর না তোরা
Mr. Pan,
মানে
what
But
we
I
say
tell
to
you,
this
Lordship,
Onimesh Goswami's matter.
but I tell you, Lordship, because Onimesh Goswami, but what happened?
No, are you ready or you are not ready?
But I tell you, Lordship, under the scheme of employment, in as per the recommendation of the Chief Judicial Magistrate, 20% were eligible for the scheme, and Supreme Court said that this is final. No one can challenge the report.
Onimesh was within that.
Onimesh Goswami, he didn't sought for employment. He sought for rehabilitation.
No, I want rehabilitation now
So,
also.
my lord,
Wants rehabilitation.
my lord, let them produce the document that they are the who has nominated whom to has nominated. The legal layers is there because Onimesh Goswami
He's no more now.
no more now. So he cannot nominate anybody. So that is required
He
to be
will
proved.
not nominate.
He cannot nominate.
Yes.
Because the nominee cannot again
Yes.
nominate.
Yes.
So it's the
No,
original.
I have every doubt whether he is a nominee or not, or whether he's a genuine land loser or not. Because I know that I
it has been
don't know, I don't because what I am on is this one. Let them file the
Onimesh-
let them file the amendment to this effect. If the legal layers of the Onimesh is the
One thing,
party to this
one
writ
thing.
petition,
No,
he
no,
can say
Onimesh
the-
legal says is not necessary to be
so
party.
how you are interested?
I am the landowner.
Mr. Pan, Mr. Chatterjee, please hear this. As this is your stand that Onimesh did not turn up and you are ready and willing to give rehabilitation
Yes,
to Onimesh.
yes.
So now let us take part by part.
Yes.
If Animesh's case is concerned, now
Yes.
it's not in dispute, but Mr. Chatterjee has to prove documents that he is
Yes, yes. Is what I am on.
that he will produce.
Yes, yes.
So Animesh was also a nominated person of the original land.
ওটা কি nominated person ছিল?
Has to be.
আরে বাবা তোর অ্যাফিডেভিটটা দেখ না সাপ্লিমেন্টারি অ্যাফিডেভিট দেখ দেখলেই বুঝতে পারবি
Onimesh Goswami, Onimesh, Ponoi Kundu. Yes, one Ponoi Kundu was the original owner.
Yes.
হ্যাঁ
So
পোনাই
he nominated Animesh.
Yes, yes,
কোন্ড স্টিল অ্যালাইভ
So Animesh was also a nominated one. He is not the original one.
yes,
So now the nominee died.
yes.
So the original land loser, he has nominated Mr. X. So you consider that. So as far as this, in place of Animesh, I give Mr. Chatterjee liberty to apply before you take a decision.
Yes,
You said that you
That
are
can be
ready
done.
and willing to
Yes, yes.
consider his case.
yes, yes.
He will produce all documents. He will
Yes.
be taking a
Including the death certificate also.
yes,
Yes, yes,
including death
everything.
certificate and other
Yes,
documents.
yes, everything.
If you want to verify the whether that original person Pranay was a land loser, you
Yes,
can
yes.
verify everything.
Yes,
That
yes,
has been
yes, yes.
accepted by them.
Yes,
In
yes.
their supplementary
I
affidavit.
don't mind for that. But only thing that not under the not for employment, but for the rehabilitation.
Yes, yes.
That is that thing.
Strategy
Yes.
rehabilitation.
Not for employment. Hmm.
হ্যাঁ চেঞ্জ হবে না রিহ্যাবিলিটেশনই হবে ইয়েস ইয়েস
Take instructions. Do not
এই যে
make
তুমি
submissions.
ইনস্ট্রাকশন নাও ইনস্ট্রাকশন নিয়ে আমায় প্রপার্টি বলো চেঞ্জ হবে না কিন্তু স্ট্যান্ড ইয়েস ইয়েস ইউর লর্ডশিপ কাইন্ডলি কিপ ইট পেন্ডিং ফর 1 week or at the time of amendment that will also be considered your lordship
Because don't make submissions. Thereafter, the client may say something. You will
yes
be in
yes yes
problem.
yes
I don't want to put
no
you
no
in
no no
problem.
my landed junior will take instruction because at the
when
time of
Mr. Pan is saying
no 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 no
because their case is rehabilitation.
rehabilitation
If you agree to
No,
rehabilitation,
at the
I
time
think
of conference he said Animesh Goswami was physically unfit so he cannot do any employment in the colliery area
now if you say
now
and the nominee wants employment.
that shift cannot be changed because it has already been shifted
That
to
is
that.
for you to advise your client
Yes, yes, yes.
while taking instructions.
তুমি ওদের আগে
Sir,
Madam,
Yes.
Huh?
Mr. Chatterjee, please take back the.
Yeah, okay.
Hey, ওটা ফেল। Item number 7.
It had a zero spread. Yeah.
This matter has come at my
Correction?
instance, my lord.
Yes, what correction?
My lord, correction, you know, kindly come. Page 5 of your,
Yes.
you know, the director forward the matter to DLLR. Actually, the principal secretary is the authority for cancellation of the.
Yes. What is your instruction? Where is Mr. Banerjee?
My lord, he's in court number 1. Lord, he's in court number 1, my lord.
What do you say? Who is the authority?
Not the not only last occasion.
Right, pass over. Ask Mr. Banerjee to come. Yes, next.
Instruction now, dear.
Yes.
Plan for the petition.
Yes.
Well, it's a voluminous affidavit of service, my lord.
Yes, private respondents received.
My lord, received.
When? When they received?
Oh, my lord, private respondent, I'm sorry, my lord, I stand corrected, my lord. Private respondent, if your lordship kindly come to my affidavit of service.
Yes, received or not
No,
received?
my lord, insufficient address. Now, difficulty is, my lord, is second round of litigation. In the same address, my lord, earlier occasion, my lord, appeared and contested. And my lord, this time on the same address when it was sent, my lord,
All insufficient
Yes.
address.
my lord, one has been received. And other, my lord, I've got the return envelope. They have just,
Where is the affidavit service?
yes.
Who has received?
কত কি আছে করেছে?
Affidavit service filed in court. Yeah. Encroachment.
Yes, yes,
State you have served.
yes.
Who is appearing for the state? Government Prior's office you have
Yes,
served.
yes, yes.
Yes.
Lots of will find it. From the page 3 of my affidavit of service.
Yes. Who has received? Please tell me.
নামটা ক্লাসে নামটা
Yes. Who is for the state? Yes, sir. Can you appear? Please give a copy. Do you have an extra copy?
দিদা
Affidavit Yes, next. Yes, Mr. Banerjee, who is the appropriate authority to take? Your learned friend says that it's not the, it's the principal secretary, not the district magistrate. Because on that date, it was told that the district magistrate. So I directed the principal
No, no.
secretary to forward this.
The statute doesn't not mention principal secretary.
Government.
Government. It is given, lease is given by the governor under the sign of the governor, my lord. So government has to take a decision. Now, let my learned senior friend show that it mentions that the principal secretary only can take a decision. I don't know, because governor has given, not neither the DM nor the principal secretary. I requested, they also made this prayer at the time of hearing of the writ petition that let it be principal secretary. I requested that let the DM take the decision because he is at the helm of affairs so far as the district is concerned, firstly. Secondly, because of the impending election, my lord, the principal secretary is asked to take a decision on this matter, my lord, that will be delayed.
That is another thing.
DM, if after that, my lord, vetting is required from any authority, it can be forwarded. First, a decision has to be taken on the matter.
He is not the authority. My lord, just your lordship kindly bear me to clarify this. I have brought two things, my lord. It will be, my lord, clarified once for all.
Yes.
As per manual, principles and procedure for settlement of land for non-agriculture purpose. 216. Joseph 216. Land Reforms Department. Lands for non-agriculture purpose shall ordinarily be settled on the long-term basis. Where long-term? ওটা তো amended আছে. Land and Land Reforms and Refugee Department. Actually, land belongs to this department. And apart from this, এটা দেখেছো এগুলো তোমাদের সব নবান্ন ল্যান্ড সেটেলমেন্ট পলিসি একটা কপি দিয়ে দাও আমি তোমার একই টেবিলে বসা দিয়ে দিলেই তো ঝামেলা লাগবে আরেকটা দাও এটা দিয়েছি না এটা দিইনি।
It's the collector who shall identify suitable plots.
No, no, that is thing, but
Then
the
You want
lease,
long-term settlement.
yes,
So that's
long-term you also kindly see there are
220. It's the collector DLLRO.
220.
Yes.
Identify plot for
With a view to long-term development.
no, no,
The authority
this
at the
is-
first
no,
instance.
no, this is the procedural part. The
Procedural part has to be complied with. He has to take a decision. Who
No,
has to take a decision?
you also kindly see. Just thereafter, the government has formulated a policy
Yes.
with regard to the land settlement. এটা একটু জোসেফকে দেবেন
Yes.
এটা একটু জোসেফকে দেবেন
Policy, who is the authority?
who is the authority your lordship kindly come মানে Roman 3
Roman 3.
yes first your lordship kindly see 1 land allotted to any individual company such and such would be transferred by the government and its pedestal by a long term settlement. Now your lordship kindly come 3 land and land reforms department is the nodal department for internal transfer and long term lease of vested cash land such and such land and land reforms department. So DM is not the authority.
You file an application. File an application for modification, not on oral prayer. This cannot be done. Please file an application, state all these facts. Then otherwise someone will then come up and say, no, 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 this was not stated. This was. Please file an application. Please file an
Yes.
appropriate application. I will consider that.
My learned friend is saying
Once I went to the Navanno, to the secretary said it go to the assistant secretary.
All right. So you
Yes.
take out an application. Otherwise,
It says a
not
committee.
tomorrow, principal secretary, another lawyer will come and say, no, 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 this is not your authority.
Secretary does
actually
it.
Please file an
that I will do
application.
it.
Mention all this. Let him also take an
I'll
instruction.
take instruction.
Personal
The Now comes assistant secretary. I do not know whether that authority is a party or not.
But principal secretary is he is the higher authority.
That I
Power may be delegated.
that I do not know. You file an application stating all this. Cannot be on our oral prayer.
No,
Yes.
He said he forwarded me 4 rooms.
what petition is
Assistant
there like
was founded assistant secretary started off.
Yes.
that is
My lord, I am for the petitioner. I have served to all the respondents.
What is this?
My lord, I am paying for taking steps against the illegal and unauthorized excavation of stones from the royalty land of the petitioner. My lord,
file an application based
Illegal digging of mine
yes, my lord, stones.
by the private respondent.
Private respondents without any authority, my lord. My lord, I filed representation
Page
before the
33, my
concerned BLRO concerned, and BLRO, my lord, after investigation, my lord, filed report and come to page, my lord, 25. Notice was issued to the petitioner as well as the private respondents.
What happened at the hearing?
Hearing was conducted, my lord. Thereafter, my lord, page, my lord, 32, my lord. Kindly see page 32.
Yes.
May I read, my lord? In this connection, the undersigned, along with his team and police personnel from your end, conducted a field inspection of the said plot, such and such. However, on the date of inspection, no ongoing mining activity is found at the site. It was observed, however, that the land had been excavated earlier, and it appears that some mining might have been carried out in this past.
Yes, Mr. De, what is your
Despite
where is the
this,
order
my lord,
passed on
no
the
steps
hearing
taken.
which took place on 11th of February 2026?
Thereafter, no steps taken, my lord.
my lord, no steps is taken by lord. So DM
So
is
you
the
communicate the order of the hearing which took place.
yes, my lord.
The petition.
But then I have for the petition.
Yes.
Well,
So I'm waiting for this respondent.
And for the 5 days.
Well, encroachment, read, order, page 19, my lord, and page 20 is the
Order passed under
under, my lord, order
62 Act.
62 Act. Then, my lord, kindly look at page 20. Let the respondent 5 or consider representation such and such, and preferably within 8 weeks. Then, my lord, the SDO took the decision. Page, my lord, 20A.
yes.
After careful perusal of the documents, reports, and
Then what happened?
then, my lord, non-compliance, we filed a contempt application. My lord, Mr. Assis Jaishankar Gupta said that you approach the writ court. Hence, this writ petition. We requested the authority, my lord, again, page 33, that this is the position, you take action. Nothing has been done.
Lordship, I have received an instruction in Lordship. The date is already expired, Lordship. We have given the last chance and asked him to vacate the unauthorized construction without wasting any further time, Lordship. We have issued the letters to the private respondents and another letter issued by to SDO by the BLRO for the seeking help for the forces. Please, Dada.
My lord, I am for the private respondent. I prefer an appeal against the order of the SDO, which is pending disposal before the appellate authority. Prefer that shall appeal.
You have preferred an appeal
My lord,
before the district magistrate.
the appeal was filed on December 2025, my lord.
December 2025.
Yes.
To dispose of the appeal.
Lordship.
Yes. Because they have not, my lord, disclosed anything.
No. As the appeal number.
A copy of the appeal
No, no.
petition to it.
My lord.
Here and now.
My lord, one copy. My lord, I shall.
সত্যি দিবে তো?
কেন এর আগে কখনো হয়েছে নাকি কোর্টের সামনে এসে বলছেন
না,
আপনি
না।
বরং দেন না এটা
ও আশ্চর্য কথা।
আপনার প্র্যাকটিস
আমার প্র্যাকটিস। যাক দিয়ে দিও ভাই। নিয়ে নিও কপি।
So 14th of August was the order passed by the SDO.
Yes,
So you want implementation of that order
yes.
and he has challenged that order.
It is their submission.
Not 14, not 6th of August 2025.
On 14th of August.
14th of August.
14th of August.
14th of
Page 28, যাবে বাম দিকে দেখো। Page 28.
Petitioner has approached this The photocopy of the appeal petition, private respondent.
Right.
Please,
Positively, madam.
yes,
I'm grateful.
Not appear for the writ petition.
yes.
But, an auction notice is under challenge, which
Why?
not by the lessee, not prospective lessee, by an allotee.
Is it under group 1?
It should be, because not should be.
How?
By ADDA,
ADTA.
allotee of a land.
So this is allotment of a land. All right. Yes.
Now, not there were two adjacent plots of land, not one allotted in 2000,
Go within group 5, Mr. Majumdar.
probably not a municipal matter. Municipal ki hobe na, shouldn't be a municipal matter. It's not municipal affairs. And the question is with regard to lease rent and premium vis-a-vis market value.
This rent and premium is also there. All right. Yes, what do you want?
Now, the dispute is with regard to the second plot allotted in 2001, which was
You have been allotted
two plots, not
commercial.
for commercial, for industrial use. Now, the allotment of first plot had a nexus with the allotment of the second one. What was the condition? If within 2 years, the development authority would not be in a position to allot this land to any other industrial house, then I shall have to take this. So, on such consideration, the first allotment was completed and the lease was executed, and insofar as the second allotment was concerned, I was making payment in installments. At one point of time, I had applied for a statement of the accounts, because I have apprehended that they were actually adjusting the interest component on the installment without getting the real value. But they did not answer it repeatedly. So, in 2020, the second allotment was decided to be cancelled by ADDA in 2020. Now, the matter through file notings which I had obtained through RTI applications and replies thereto had moved up to the government department, concerned department of the government. Now, ADDA had given two proposals to the government. One, either make fresh allotment at the current lease rent or resume both the lands. The government was indecisive.
Resume both the
The government was indecisive. You say that you can't come up with an alternative proposal before us. You give only one proposal to us, so to enable us to sanction your action. They say that we want to resume both the lands. But the first land is a running factory. There is a running factory on the first land. It's a steel factory. The second plot is a proposed rolling plant. Now, substantial development of the land made. Now, ADDA had referred this to the UD department. UD department said the proposal for resumption of both the lands.
That was approved.
No. UD said that if the present market value is paid, then the matter can be resolved.
Present
market value is paid, then the matter can be resolved. That's the language in the.
It's a lease.
That's my point. That they seek to employ a 2012 policy in respect of an allotment made in 2000 and 2001. But my first question would be whether this can retrospectively apply to an already existing allotment. Number two, whether market value concept can be incorporated in a lease. But lease premium, I understand, a one-time upfront payment which can be paid in installments subject to contract. That's in the nature of an implied covenant. Rent, it's agreed. It can't be market value of the price of land.
Then he will become the owner.
Yes, it's sought to be given to me on lease for the purpose of limited enjoyment. It's only transfer of a right.
Becoming the owner if you pay that.
They are not doing this. No, they are giving this on lease basis subject to transfer of interest for the sole purpose of not running this factory. I can't use the land on my own for my own purpose. It's only a transfer of an interest.
You are challenging any decision?
Yes, please see the auction notice at page 76.
Oh, the fresh auction after that,
Yes.
after cancellation. So you are challenging the cancellation as well as
The
the
auction.
subsequent decision to auction it.
Right.
Where is the order cancelling?
But please come to page 42 first.
Where is the show cause notice prior to cancellation?
Not they have referred to a show cause notice not dated
24th of September 2001.
2001.
Where is that?
Not my client have given me a specific instruction that no such show cause notice was received by him, but not,
Mr. Chatterjee, where is the show cause
of course not
notice?
subject to their
Not been disclosed,
producing.
Lordship, here. This has not been disclosed here. Lordship, when thereafter,
No,
after,
where is the show cause notice? Please, you disclose that.
I do not have it as of now.
Then how can you cancel this? And this order refers to a show cause notice.
Lordship,
If
after,
you don't have the show cause notice, your very basic foundation goes.
after this was cancelled, the matter was sent to the UT department, and UT department said you do not cancel, but what you do, you ask for the current market price. It was like
So
that.
now,
So this was given a
has
go
been
by.
given a go
This
by.
was given a go by.
All
I
right.
admit that.
All right.
Thereafter,
So
my lord,
now-
the writ petitioner filed a
Writ
the writ
petition.
petition
Yes.
saying that you give me the draft lease deed.
No. So
Thereafter, I will not
no, after this has been given a go by. There has been no termination.
There has
Not-
been an order of the Honorable High Court.
Not there was a writ petition filed seeking for the draft deed of lease.
Yes.
Now, not when that writ petition appeared before a coordinate bench, his lordship said, "How can you enter into an arrangement without this being auctioned?" So, not there was no final order, but a report was called for. But I have annexed that order. I'm not from that my client
other
went,
orders as well.
my client
Termination order is
No.
there.
There were orders, my lord, I am handing over that order. There is an order, my lord, specific report was asked for that when we are going to auction the property. Mr. kindly takes up. It has to then.
but I believe it is page 65.
No, no,
না,
no,
না,
no,
না।
order.
আরো
22.
এছাড়াও আছে
আরো অর্ডার আছে এটা 24 অর্ডার জুন 24
20th of June.
Yes, 20th of June. Yes.
Kindly takes up, lordship, that in the second page, that mere pasting of a piece of paper at the entrance of the subject premises does not amount to taking necessary steps for re-auctioning of the subject premises and is an empty formality. Let this matter appear on such and such when the chairman of the respondent number 1 or his delegate is directed to file a report as to what steps have been taken for re-auction.
Then what happened?
Next order, lordship, kindly takes up 27th of June.
Yes.
Here, my lord, in the page number 2, the additional chief secretary, government of West Bengal, who was authored the communication dated such and such, is directed either by himself or through an authorized representative to file a report as to what immediate steps are being taken by the state authorities as well as ADDA to re-auction the subject premises.
Then what happened?
Then we have filed the report before the honorable court, and my lord, steps were taken for auctioning it pursuant to the order of the honorable court. This order was never challenged.
There are two aspects of that matter. First is, without cancelling, how can you auction it? Satisfy me on that.
Lordship
issue
kindly
first.
takes up the order at page number 65. You know, the writ petition.
Yes.
What I will say. Lordship,
This
this-
12th of June.
yes. After this, these orders were passed.
So 12th of June, what it has been said.
12th of June, it was
Similar
clear
order as it appears.
that
Please come to page 66.
66 lordship in the second last paragraph.
Yes.
It is submitted on behalf of the respondent ADDA that though they had every intention to take possession of the project premises, but they were advised by the additional secretary, government of Department of Urban Development and Municipal Affairs, government of West Bengal, not to take any steps against the petitioners. In the above circumstances, let this matter appear in such and such for to file a report as
Without cancelling, how can you auction that self-some property in further?
Lordship, this matter, Lordship, these orders, these were not appealed against.
No, no, one of the orders was appealed against.
It was
No,
withdrawn.
withdrawn.
It was withdrawn.
It's annexed to the
I used to
petition.
say that whether this present writ petition is at all maintainable.
This writ petition is pending.
Yes,
Pending.
pending.
Mujumdar, then this has to be heard along with that.
Yes, please take these two matters analogously.
It's before that bench, go before.
I don't think that bench has determination. His lordship doesn't have determination as of date. Kindly brings this file here.
See, what I candidly submit, what has happened, we were, my lord, very much rebuked by the honorable, my lord, judge.
Lord, it's really in the
Thereafter, it
under
was done.
something like threat of contempt.
Thereafter, it was, yeah, that's the way. Thereafter, it was done within a week. Everything was done. We taken possession, we filed a report, state has taken steps for auction.
Lord, we preferred an appeal from that page 65 order. The honorable division bench said, how are you aggrieved? This cannot be maintained as a letters patent appeal because nothing has been decided.
It was withdrawn.
Then,
It
how
was
can-
withdrawn.
Everything is finalized then.
It has not been.
How can you now challenge the
But
termination?
without the writ having been decided, there is no adjudication. So there can be no res judicata.
Constructive res
No
judicata.
decision on merits.
If you have raised that point, you have withdrawn that.
No, no,
Yes.
the
Constructive res
Say
judicata.
that it has not been decided. It has not been decided.
No, even if not decided, if you have raised that point, then you have withdrawn.
The
Yes.
matter has not been. I can.
That you have not pressed that issue.
I
Will be constructive res judicata.
I
Mr. Mujumdar.
can't. Please see, this is a subsequent event. Number one. Number two, I can't prefer an appeal unless it is maintained as a LPA, which is in the meaning of clause 15.
I will remember that, Mr. Mujumdar.
No, of course, not your,
That-
your lordships have now decided not in that Shamsel's judgment. But although not that 81 judgment has been extensively relied upon. কি নাম জানো ওটা? যেটা সবসময় 81 সুপ্রিম কোর্ট আহা কে দিয়ে না Today, one is a running factory, the other is a prospective factory. Substantial development of the plot of land made. The government does not want to
If you
resume.
Resolve it out of court, I have nothing
Yes.
to say.
But please
But
see
if
the
it has to be decided on merits, that's another thing.
no, please see page 59. Please have a look at page 59. The government does not want to resume.
Yes.
Now, Mr. Mujumdar, the fact is that on one hand, you are saying does not want to resume. But on the other hand, auction process means without resumption, how can it be done?
That's the point.
But that has been done, you have accepted
No, no,
that.
no, no. Please
What-
come.
what
That
are the
petition is
resume
pending.
process?
That has not been decided.
But these are orders.
Not-
Even interim orders, those are binding between the parties unless and until
These are
set
not.
aside.
What have you done? File a report. What have you done? File a report. The government files a report. The court has not decided it. Nobody's right has been decided in the writ petition finally. But in a subsequent action, I could have either preferred a separate writ petition or I could have tried to not onerously amend the writ petition and bring these subsequent facts on record, which your lordships normally do not encourage.
Not only file a report. There is a specific observation.
Observation.
There's no
Direction.
finding. Despite there being no interim order in favor of the petitioners, neither ADDA nor the state respondents have taken any steps whatsoever to resume possession of
Yes.
2 plots of land. And after that, we were directed.
Not directed.
You have pointed out to the court,
What to have?
could not have been done auction
Yes.
unless it is terminated. And you say there was a notice of cancellation. You have said that it has been given a go by. So you cannot take these two stands at the same point of time.
Our stand was that
If you rely upon this letter of cancellation, it's one thing. Then you have to satisfy that there was a show cause notice adjudicated in that way. Principles of natural justice was followed. If not, that is a very good ground to set aside. On the other hand, you are saying we have given a go by, that's end of the matter. So if that's end of the matter, then a subsisting lease may be a defaulter, but the lease is subsisting.
No, in respect of the second flat, lease was not executed because I filed the writ petition to get that.
lease has not been
Lead has
The past you have cancelled.
Lordship,
An auction is for both.
Lordship, as far as
Auction is for both.
No, it's a second plot.
Second one.
It's only
not
the
the
second.
first
Second one.
First one, there was a lease and there is no dispute with respect of that. Only second one, allotment letter was given, he didn't pay the money, and later on we decided to resume. UD said that no, you pay the market value, and so we said that we ask for the market value at the present current rate.
And the REIT was for only
It
for
was-
that, for market value.
Market value for lease. How can you take the market value? Same price, lease rent as well as market price. Can it be done?
That was agreed upon. They had
Show me
agreed.
the agreement.
Lordship,
Show me the
they
agreement.
said that they own. I'll have to take. Kindly allows me to file a report. There are documents disclosed in the earlier writ petition.
But here I have disclosed
All these, my lord, that is, my lord, my learned senior friend is trying to canvass in this writ petition ought to have been made part in the earlier writ petition. And those orders have not been challenged.
at page 60, I have wanted a reply from the the authorities as to what would be the terms and ask for a draft deed.
And
when the auction is going to be held?
It's date page 76.
No, auction conducted.
No,
When?
it does not refer to any particular date, but there is a program at page 79. 10th of April 2026 is the bid submission end date.
10th of
April.
April. So tomorrow.
Tomorrow.
Hard copy.
auction
Then
end date is
approval
30th
start
of-
date. Auction is 30th of April.
Yes.
30th of
Approval end date is 28th of April. Have you participated, Mr. Mojumdar?
No.
So here it says where is the value, the price it has been
That's at
indicated
page
here.
78.
List the land in auction for what purpose? On long-term lease basis for 99 years. So, any provision for payment of yearly rent?
But it is not provided in this. But probably they are referring to the land policy of 2012. Probably.
What does the land policy say
But
that
It's at page 69.
page 69? No, is it year to year lease rentals you have to pay? What's the policy?
It says that have been allotting and now please come to paragraph 3. Now at page 69. Now the governor, after careful consideration of the matter, is pleased to make
69. Yes,
Paragraph
yes,
3.
yes.
to make the following land allotment policy which will be applicable
Show
to
me that relevant subclause with regard to lease rental.
please come to next page.
Yes,
It would be rather a continuation from clause 3 at page 69.
yes.
The Land and Land Reforms Department is the nodal department for interdepartmental transfer of land and long-term lease of vested Khas government land. An interdepartmental committee under the Chief Secretary would handle all cases of interdepartmental land transfer. The valuation for LTS.
Bojumdar, this the policy. Then unless you
No.
challenge the policy,
Yes, the value. Not the first is not whether this can apply to this at all or not.
the valuation of LTS would be based on the
Sale deeds of the area or the market price.
So it's basically 99 years lease is basically a sale.
Almost a lease in
Lease in
perpetuity. Yes.
So that is why they are taking this money. You did not pay, I think, yearly or
Still, Millard, the elementary principle of lease cannot be ruled out.
But if it is, they are taking it for this lease rental of 99 years.
Not lease rent.
So
Not,
if you can transfer, you can recover from that your assignee for the balance period, balance amount. That's subject.
that's something subject to the agreement
Yes,
or
that's subject
conveyance.
to the agreement.
But not number one, whether this policy can at all apply to a land which has been allotted in 2001.
Now, Mr.
Under the government
yes,
code.
yes. One is
Same.
you have not, that was not allotted in your favor.
Yes, allotment meant.
No contract lease deed was not executed.
Lease was not executed, but allotment made.
So you have a right to get a lease deed, but you have not yet got a lease deed.
That's right. That is why I approached
for
the court.
that, So unless there is a lease deed has been executed, can you say that no, this policy, subsequent policy,
Please visualize.
right of yours have been
Please visualize.
crystallized?
Please visualize this from two angles. Not one. In the event the allotment cancellation goes, or the government has decided not to carry forward with the allotment cancellation.
Now the question is specific performance.
That is,
Now the
the
question
government
is
has
performance.
the government has
of a
decided.
contract.
The government has decided not
You
to.
have, according to you, you have performed your part of the contract. They are not doing.
No, please.
So specific performance of contract file.
Yes. No, please come to page 39 once. That's all not where it got stuck in 2001 and 2. I wanted a statement of accounts.
Now, Mr. Mujumdar, one thing.
Now, if this 2020 cancellation or not, what was the 2001 notice for? 2001 notice could not have been the basis of the 2012 policy could not have been the foundational basis.
Quite without a lease deed from 2001 till 2026.
But I had continued not giving installments in the meantime.
That's one way of looking at it, but
Right.
you have not got the lease deed.
That's right.
You not have any right.
So not I had
But
applied.
the amount was not paid.
Applied, you are kept quiet.
No, I have applied.
Without,
I have applied to this court for the purpose
Without
of this
payment.
execution.
Without
Applied
payment.
to this court for the purpose of execution, which the government, after the government decided not to carry forward with that cancellation.
that's a different thing altogether. A cancellation is one thing, but if you had to file a suit for specific performance, you may say that 226.
But I have.
There is no period of limitation, but there are line of decisions which says that similar periods of limitation for same reliefs that can be applied here. So specific performance of contract of an allotment of the year 2001 is the writ petition. Can you pray for specific performance in 2024 or 2022 also? Not have.
A 2026 auction notice is based
Auction
on.
is a very different thing. First is you want lease deed that you have not done. So unless
suppose
there's a
not,
lease deed, what was the crystallization?
Not, suppose not I succeed in the first writ petition.
Mr. Mujumdar, I think the other writ petition has
Yes,
to
please
be.
bring those two not and kindly not let it not be finalized.
Actually, in the other writ petition, my lord, there is no prayer for execution of lease deed. It's only
That I will consider, but
it's only
these
for
are auctions and other things are to be
this ought to have been made a prayer in the earlier writ
not to finalize. Mr. Mujumdar, do you intend to participate? If you intend to participate, please participate. Thereafter, I will consider because in the meantime, if it is against you and you don't participate, everything goes.
Yes. But kindly gives that liberty not with a.
If you say so, I will provide it. You take and coming after 5 minutes, you take instructions on that.
And my lord, limitation for said is 3 years. My lord, I already
Without prejudice, subject.
You will participate. That date of submission of technical bid or techno-commercial bid has expired, or it's still
No,
there?
it's till tomorrow.
Till tomorrow. You can do it by tomorrow?
Kindly gives me till Monday, extends it till Monday.
Till
Mal-
Monday. But
Mal-
the difficulty, Mr. Mujumdar, I'm telling you now, it's online. So online system, after that date, it stops.
That
Yes.
they can do. That they can do not because the approval start date is 17th April.
Because I faced one problem in another matter. That is why I'm telling you. Can you not do it by tomorrow? Otherwise, online you will be facing difficulty. Then they will be saying no. Without online we cannot consider. What's there? You can online. You will be only submitting that. And
I don't know whether any
where is
other.
that? Where is that NIT?
It's the auction notice is at page 78. It begins at page 75.
So that schedule, please
That
take me to the
schedule is 10th April is the bid submission end date, including EMD. But this EMD may not be able to be procured by this time.
bid submission start date is 11th. Bid submission end date, including EMD, is 10th of April.
Yes.
This EMD may take time. Now I'm not.
How much time it takes?
Not
Not EMD in the form of a bank guarantee.
But if it is bank guarantee, it will take 2 to 3 days at least. Not after. Yes, nowadays, not if it exceeds a certain figure, not it will go to the zonal office, something like that. It takes some.
And my lord, relating to the
No, it's not online. This is not online.
Has to be because it says
But it has not been stated here.
it says that online time applicable for e-auction shall be as per the server clock. So
No,
it's
that's
probably
that's is I think this auction quotation, bid quotation will be financial bid will be online. Yes, Mr. Chatterjee, what's the procedure? It's your
Online.
it's
online.
It is in online.
online.
Auction website. It is in the earlier in paragraph, page number 78.
Page number
78.
E-auction will be done.
Through web portal.
Web portal.
কিন্তু EMD-টাও কি অনলাইন? হ্যাঁ, নরমালি তাই হয়।
Upload normally.
And submission of hard copy at the authority's office. So bid submission is online. It appears so. And you have to submit the hard copies on such and such date. Yes, Mr. Chatterjee, can you not accept the physical copy? Or I will direct you to extend for online, but then the problem will be others may also come. Others
Will be
may
other
also,
bidders.
Other
other
bidders.
bidders may also come.
Other bidders
So,
can't be similarly situated like me.
My lord, this is mere allotment.
But
Allotment
no,
does not.
he also will
Here only the claim of the petition is only mere allotment. Allotment cannot create a right.
Mr. Mahato, that's a different thing. I will decide that this is with regard to this face auction if he wants to participate without prejudice to his.
Yes, in respect of without prejudice, my lord.
That is what, because he is not waiving his right of challenge.
No.
Physical copy, allow him to do physically, otherwise that might be a problem. Because the EMT, as
Instruction
Mr.
can hear now.
Mujumdar has said rightly, because 1 or 2 days it might take.
Then kindly allow him
Saturday
to
being a bank closing day.
take instruction, at least my lord kindly passes it over. What will be the difficulties faced by the officers? My lord, I need to first understand.
Then you have to keep it open, allow him to submit online for that.
Can be extended till through a corrigendum order.
Online, I have no difficulty if you can extend that. Now it's open, you can extend that. It's no difficulty, but only to protect you because others can also come. That is why to protect you, I am saying if you can accept this physical, I think this can be.
But there is a gap of 7 days between the last bid submission date and the approval start date.
Yes, that's
So not
there is
if
no
no,
difficulty.
no, I'm only submitting this, not for Mr. Chatterjee's
Yes, there's no difficulty with that. I'm only concerned with the.
Monday is 13th. If it could be to a corrigendum notice, if it could be extended till 13th.
Corrigendum notice.
No, my lord, that will further litigation.
Post order, it can be only
That's right.
restricted
That's
to you.
right.
Not by your corrigendum, then it's other.
The lordship is thinking about other prospective bidders.
No, I'm not thinking of other prospective visa if they do not want, but they will also be joining. That is why. I'm not. I do not intend to extend this for others. Since you have approached this is pending, and you are an allotee. Ashok. Please take instructions. I'm only.
That whether this EMD can be handed over in a hard copy format or.
All right, Mr. Mojumdar,
that will
that's
suffice the
yes.
purpose.
So I think that will suffice. So you can hand over. You can submit the EMD along with the hard copies. You submit your online other formalities by 10th. I think that will.
That can be done.
Do that with regard to the EMD. I permit you to submit along with the submission of the hard copies 1 or 2 days thereafter.
As it appears from that notice, there are two modalities for consideration of the documents, both hard copies and online.
Yes.
Online maybe for the others to view.
Yes, because hard copies you have to, even if you upload that, you have to submit the hard copies. Ashwin. Next. Number 12. আচ্ছা ওইটা list this matter along with you are for the
I am for the petition.
petitioner.
Yes, ma'am.
Yes.
And for the
Lord, what happened, my lord? The petitioner's premises is adjacent to, my lord, the government road, and in between government road and my lord petitioner's premises, certain some portion of vested land. And my lord, it is used by the petitioner for ingress and egress. But my lord, it is, my lord, covered by way of fence, paka fence,
By way of
fenced. And therefore, my lord, the petitioner's frontage is totally blocked. And my lord, petitioner made a representation to the subdivisional officer, my lord, Tomluk subdivision, and my lord, page P7. And in the meantime, my lord, honorable court's direction, my lord, the authority, my lord, BLRO has filed two, my lord, the report. My lord, first one is my lord 7th day of January 2026, and my lord second one, my lord, is affidavit on my lord 14th day of January 2026, wherefrom my lord it is clear that the petitioner's contentions of the writ petition is correct, and my lord the hand sketch map shows
who is for the private respondent?
My lord, I am appearing.
Yes.
Lordship, the DAG number 1015 is belongs to my land,
Yes.
and I am here on my own land 1015. I have made fencing on my own land 1015.
Report does not say so.
My lord, what happened? From the report, I found that the village road, the bath, has been constructed through my land on the particular position, and the remaining portion of my land remains on the other side of the road.
So 804, you have not made any fence on 804?
My lord, I have made the fencing on the other side of the
No, have you made fencing
road.
on 804? No. You have made fencing on 1015?
My lord, I have made fencing on
So
1015.
you do not have any objection if the fencing on 804 is removed? You have no objection.
My lord, I should not have.
1015, they will not touch
Lordship,
804.
My lord, I should not have. But in this particular,
But you have.
in this
You should
particular,
not have, but you have.
Lordship, kindly
This shows that,
consider,
that
my
you
lord.
have put the fencing on 804.
My lord, not like
804,
that.
that has to be removed. You do not have any right to put fencing on 804.
My lord, in that regard, the authority should not have any right to encroach my land to make the road instead of 804.
For that you have to file an application.
Yes,
You have to take steps. For that does not give you a license to encroach upon, to put
My
a
lord,
fencing on other plot.
that is not the case. Actually, my lord, in the
Then remove
context,
804, you have not put fencing. I will record your submission and I will direct them to remove all fencing from 804.
in that case, my lord, also direct
The
to.
more you argue, it shows that you have put fencing on 804.
My lord,
You should have really readily agreed. Yes, let it be removed from 804. The more you argue, so it shows that you have put the
my lord,
fencing.
I came to know after the writ petition filed that I have made fencing on 804. But
Thank you, sir. So let it be removed from 804.
my lord, kindly for a moment. But I found that the road has been constructed through my land.
Take steps. I give you liberty to take steps for that.
And
Removal
my lord,
of road,
I have not intentionally blocked the remaining portion.
I will record that unintentionally. If you have done something, they will remove that.
That is, my lord, done in the concept
Intentionally, they will
that
remove that. Or
my
you will
land
remove
my
that.
land is there.
If you want to remove, I
My
give you
land
that.
is there.
You want to remove from 804. Then some fencing, those articles, you can get that then. If you undertake that you will remove, I can give you that. So something, some
My lord,
of your property,
I shall remove the remaining portion.
804 you will remove. File an affidavit to that extent.
I can, my lord, in that case, my lord, the road should be shifted through 804.
No conditional order. Asun.
Road should be shifted through 804.
Petitioner here.
My difficulty will be the same like the petitioner, my lord.
You are not the petitioner here. Yes, the petitioner.
The report in the report page 9, my lord, the report of the revenue inspector.
Yes.
My kindly see paragraph number 2. আড়ং মৌজা স্বয়ং জেল নাম্বার 804 দাগটির মোট পরিমাণ এত যা পশ্চিমবঙ্গ সরকারের পক্ষে কালেক্টরের নামে রেকর্ডভুক্ত রয়েছে, যাহা বর্তমানে সম্পূর্ণ অংশ বাঁধ থাকিলেও বিতর্কিত অংশের কাছে বাঁধ হাল নকশা মোতাবেক না থাকিয়া 1015 দাগের উপর চাপিয়া রহিয়াছে।
1016
না আর নিচে প্যারাগ্রাফ 2 তে 1015 দাগের উপর চাপিয়া রহিয়াছে। আর 3 নম্বর এত দাগটি 12 ডেসিমেল এবং যাহা বিবাদী এবং তাহার ভাইয়ের নামে সম্পূর্ণরূপে রেকর্ডভুক্ত রহিয়াছে।
804, the report says that you have done that. Ashun,
My lord,
the petitioner.
My lord, paragraph 7.
7.
Yes, ma'am.
The petitioner alleges
revenue
Text, I've
inspector's
given you
report.
liberty.
Report
I've
that
given you liberty.
my property has been encroached by the.
Text. Yes.
But in this matter, I am for the petition.
Yes.
But in this matter, earlier the losses given direct
For the
and
state, my lord.
my lord, to serve notice again, private respondent as well government, and to file affidavit in service.
You are for the.
I am for the state, my
I
lord.
am filing affidavit in service, my lord.
Yes.
In this matter, my lord, petitioner lodged a complaint for my lord occupy the private respondent public land, my lord, and kindly see my representation.
Encroachment.
Yes, my lord. Kindly see my representation annexure P3 page 15.
15.
15, my lord.
They have received, private respondent received.
Yes, my lord.
The every service filed in court today is taken on record. The last
I am
Yes.
the petitioner. But this matter, my lord, on last two occasions, my lord, the state was not represented, my lord, in spite of the specific orders by this honorable court, my lord. And lastly, my lord, I have also, my lord,
You are appealing for the state.
No, I am for the corporation. Vidhannagar Municipal Corporation.
my lordship will kindly seize the orders, my lord. Specific orders have been given, my lord.
Who is the answering respondent? State.
State, yes. But this is in respect to, my lord, I have sought for quashing of the, my lord, the proceeding under the West Bengal, my lord, this unauthorized occupants land acts, my lord. Because it's my case is that, my lord,
Because you are encroaching.
no, I am the owner. Government is encroaching. My lord, it's totally, my lord, it's a different case over here.
So you initiate a proceeding under 62 Act, evict the government.
Well, till date, nothing has been shown.
State online, case state. Yes, who is appearing for the state? You are not audible, sir.
Yes, my lord. In this matter, my lord, I am appearing on behalf of the state, my lord. In this matter, my lord, this property, my lord, allegedly claimed by the petitioner is the private land, not private land, my lord. It is the government property. And, my lord, now this property has been declared, my lord, as the government property because, my lord, in the case it has been reflected.
Yes, let me hear the petitioner. Yes.
My lord, this is.
Yes,
Lordship will kindly takes, my lord. My lord, this litigation, my lord, started from
Please
2011.
show me that you are the owner of that plot of land.
Yes.
Where is the document?
Yes. Well, the deed I have annexed, Lordship will
What is
kindly.
the plot of land in question?
Yes, well, that is at of CS. No, sorry. Excellent. Well, I have stated in paragraph, Lordship will kindly takes, my lord.
Give me the plot of land, sir.
Yes. Yes, my lord, it's 62, my lord, 62 decimals, my lord, at 4371, my lord, RS Dag number.
RS 4371.
Yes, RS 4371. And CS, my lord, 6256.
CS
6256.
LR?
I
don't have. All right.
Yes.
So you are the owner of this plot.
Well, I
Copy
have
the record of rights.
Yes. Well, record of rights, Lordship will kindly takes, my lord. No, record of rights, well, I have annexed the deed. Well, what has happened, Lordship will kindly takes first, my lord, page 43.
Deed is very well.
Very
have you recorded your name in the record of rights?
Well, what has happened, Lordship will kindly comes to page
Say
40.
yes or no.
No, it's not. Page
When
40.
did you purchase?
No, not purchase, it's a gift deed. It's a gift deed.
Gift deed from?
Within family arrangement. Within family arrangement.
Your donor's name was recorded
Yes,
in the
yes,
record of
yes,
rights?
yes,
Please show me that record.
Well, that record of rights, well, I'm showing. Well, Lordship will, before that, well, Lordship will kindly comes to page 48 once, my lord.
Yes.
Well, why I'm saying, my lord, state is taking a different, my lord, stand in respect to this land is concerned. Lordship will kindly takes, my lord, page 48. My lord, there was a writ petition file, my lord, wherein Lordship will kindly takes, my lord, the second paragraph I'm reading, man. In the writ petition, the petitioner stated to be the owner of the land in view of the certificate of mutation being annexed as
Where is the notice? Please show me the notice dated 28th of August 2025.
2025. Yes. Lordship will kindly comes to page. Page. Yes, page 101.
101.
Yes. Well, after this notice, I went there. They could not show a scrap of paper. Well, I asked.
Stop the process.
And they have not initiated any. After that, no proceeding has been, my lord, continued. Well, 101, my lord. Lordship will kindly seize. 18th September. This notice was served on me. Sorry, 18th September, the date was fixed. I don't know.
Have you replied to this notice?
Well, I went, my lord, personally, my lord, my client went with a learned lawyer, my lord. They showed that kindly show that this land is acquired or not. But they could not show a scrap of
I'm
paper.
asking you, have you replied to this?
No, well, I have not replied.
Why?
Well, they called for the hearing, my lord. Lordship will kindly, well, they called for the hearing. Well, after that, well, they did not take any steps. Well, I have challenged this notice, initiation of the notice, and I'm also challenging the proceeding itself. I am challenging the proceeding itself on the basis that the government, my lord, cannot come on a fine warning and say this land is acquired. My lordship knows much better than me. It in the statute, it has to be followed. There should be a notice.
Mr. Chattopadhyay, what are the grounds on which a show cause notice can, a challenge to a show cause notice can be entertained?
Well, first,
Please
yes.
show me.
Well,
those line
first
of
thing is,
decision.
subject to correction, where lordship will kindly take the act itself, my lord. If I am not mistaken, well, the government has to show that he is the owner first. My lord, ownership has to be established in respect to whether lordship will kindly takes, my lord. Well, well, if public land, my lord, lordship will kindly takes, my lord. Yes, yes. Well, section 2, my lord.
So,
4.
in a challenge
Yes.
to the show cause notice, that can be decided.
No, well, I am on a different, well, I am on 3
I'm
footings.
asking you, please, the scope, as Mr. Chattopadhyay, as you very well know,
Well, today, my lord,
scope is very limited.
very limited. Well, I bow down. Well, I bow down. The
What are
scope
the,
is.
on what grounds the show cause notice can be challenged?
Well,
What is
I
the
have
grounds?
taken 2 points before your lordship, my lord. Well, lordship will, my lord, as my lord, this is the 4th round of litigation. My lord, first of my lord, 2011, my lord, the state came. They, personally, they, on the basis of an affidavit, they showed that there is no acquisition in respect to this land. Even there is also no, my lord, project that upcoming that they will be acquiring. Nothing. Well, after that, I came for mutation. This court allowed that you go before the municipal corporation. They will allow the mutation. Well, after Bidhannagar Municipal Corporation. Bidhannagar Municipal Corporation for mutation.
In which moja this property is?
Well, moja, this is within. It's adjacent to Salt Lake only. It's a salt. It's basically within the Salt Lake.
West Bengal Land Reforms Act is applicable there.
No. I only applied in respect to mutation in respect to Bidhannagar municipality is concerned.
I am asking you, West Bengal Land Reforms
Yes,
Act. is
Moja
applicable.
Krishnapur.
What prevented you from recording your name in the revenue records?
That's
the first step. Second step is municipality. Unless your name is recorded in the revenue records, you cannot get your name recorded in the municipality. That's the law. So the even if you get that, so please
very
show
well.
me
Mala
that your
lordship
name
will
has been
kindly
recorded
give
in
me
the
2
record of
minutes of time. I'll try to record of rights. Lordship knows. I am not on. If even if I have not recorded my name, my title cannot go away. My title cannot go away. Today, what is on I am on stressing on 2 things.
That is why I'm telling you I cannot decide your title here.
No.
So you
Yes, my lord.
first you give a reply to the show cause notice. Let them adjudicate. I will direct them to adjudicate. Produce all documents there.
Let them produce.
Mr. Chattopadhyay, this cannot be done in a challenge to a show cause notice. These facts are to be gone into.
Very well.
You very well know the scope, limited scope of challenge to a show cause notice.
2 things. What has fallen from your lordship, my lord? Yes. But this is the certificate of mutation, which was annexed in
I
the.
will decide that. Yeah,
No,
at
it
the
was
time
already.
the show cause notice.
No. It was already there in the writ petition that was allowed. I'm carrying the certified copy of the writ petition. This was an annexure to the writ petition. That is only I'm showing. If your lordship kindly
That
see.
will be decided in a challenge to the show cause.
No. What I'm today, state.
Disputed questions of fact in a challenge to the show cause notice. This is the new
give me
law
2
which
minutes
you
of
are.
time.
This is the new law which you are trying to establish.
I'll not anything. New. Only lordship.
Only that these disputed questions.
Give me
can
2
be-
minutes of time. What has happened? Lordship, I'll give all the queries. Answer. The decision in respect to whether this land is acquired or not, that has attained finality. In my respect to
This is the mutation in favor of Dipali Rani Biswas.
Yes.
Who is Dipali Rani Biswas?
Petition.
So it has been mutated in your name.
Yes. But they, what has been done, they are taking 5 stands at different times.
Yes.
Once they are saying this land is acquired, once they are saying this land is not acquired, may I ask this 2 questions?
Can that be decided at the
I am not.
Why are you afraid of filing a reply to the show cause?
I am not afraid. I went personally. Let them produce a record before. Why they have not initiated anything? Lordship will also take the flip side of this. Why the state, in spite of serving me a notice,
prepare a draft of the reply to show cause. I will direct them here and now to accept here. In the court's order, I will record that it has been served upon them. Draft a reply to the show cause notice annexing all documents. Here and now, I will hand over to them, direct them to consider.
Then lordship can direct me one thing. If your lordship lordship can give me a 2 weeks time, I'll file a reply and let them decide on the basis of the whether this land is acquired or not. What is it? My as per instruction is concerned, already all things have been deposited. They have not called us. Lordship will kindly see the reluctant attitude of the.
Them to decide the show cause. Yes, why have you not decided the reply to the show cause?
My lord, that is the part, my lord. Kindly give instruction, my lord, so that that can be done. But another part, my lord,
Yes.
through the case number EV21 F26 stroke AK 139 2025 2026, it has already been decided, my lord. The state, my lord, this land, my lord, unauthorized occupant, and this petitioner is an unauthorized occupant of the public land. Already been decided, my lord.
Where is
On the second point is that, my lord,
You have issued a show cause notice. This is not your decision. You have given
my
a
lord,
show
so
cause
cause notice, so far concern, my lord,
replied
so
to
cause
that.
notice.
So they have replied
Yes,
to that. Why have you not taken a decision on that?
my lord, that instruction may be given, my lord. If the lordship
When
is
can you
pleased
come
to
back
give
with the
instruction,
When can you come back with the instruction?
my lord, 2 weeks, my lord.
The learned advocate, no, Mr. Chotto. একদম
and there is no dispute. Well, only well, in the meantime, well, let them well, an injunction be. Because well, already I was enjoying this injunction.
Status quo.
Status quo. Well, I am in possession, let there be a status quo.
নিশ্চয় তো এখানে ভোট নেই
Let there be a
Your
status.
vote is on 23rd.
No. 23rd. Let there be a status quo.
Status quo,
Yes.
without indicating at what the status is.
No. I am in possession, my lord.
Thank you.
Well, they have filed this proceeding, so well, I am in position. There's an admitted position of
The show cause notice was issued when?
18th September
Of which year?
2025.
So how many months have gone by this time?
Well, by this time, well,
You
they
have protected your possession.
well, that I am protected.
So I'm
since
sure you will be
62.
able to protect your possession till 23rd. Yes.
Much obliged.
Yes.
I'm for the response number 7.
But I'm afraid for the petitioner, my lord.
But I appeal for the state.
My lord, in this matter, my lord, I'm enjoying a shop room, my lord, in the Joynagar area, my lord. It is an admitted encroachment, my lord, in front of my shop room. My lord,
Admitted encroachment, who
Yes.
is admitted?
my lord, there's pictures, my lord, which I've annexed in my
Sir,
requisition.
admission is by the other side. Admission is not by your pictures.
Lordship, thereafter,
You started by saying admitted encroachment. I thought that they are admitting.
Lordship, thereafter, my lord, I have made detailed representation to the
Yes,
concerned
look for the
authority, my
private
lord.
respondent.
My lord, my only prayer, my lord, is consideration of the
Look
representation.
for the private respondent.
I'm for the
Yes, why have you encroached?
I'm the proprietor of that said shop room, my lord. Over the half decades, my ancestors were running that shop room.
On which property your shop room is standing?
My lord, we'll kindly see
Which
page
plot?
14.
Sir, I will come back to you.
I have the I
Which
have
plot?
all the documents I have registered.
Sir, please tell me the plot number on which you are. Now instruction. You are saying your predecessor from the time of your predecessor, you are carrying on business. Now you do not know on which plot you are carrying on business.
My lord, will kindly come to page 14 once, my lord. Page 14, my lord. This cannot be a shop room. This is a thela, my lord. Page 14 of my repetition, my lord.
Yeah.
You know, this,
Yes, state, what is your instruction?
Lordship may kindly consider my instruction.
Inspector in charge of police station.
Lordship. This is
Civil dispute.
no, my lord, no, it's not, my lord. My lord, the first, second, third paragraph, my lord. Upon verification of the police record and local inquiry, the following factual position has been emerged. Now, my lord, on 10th August 2025 at about so and so hours, a complaint was received at Dosa camp from Sri Ganesh Chandra Noskar, president of Dosa Bazaar committee, along with other committee members, alleging that one Nobin Halda, that is the private respondent, was installing a gumti over a concrete structure in front of the shop of the petitioner Sri Pollad Noskar at the Dosta Bazaar. The said complaint was duly recorded by Dosta GD number so and so dated 10th August 2025. Now, Lordship may kindly come to page 2, second paragraph. It also says in this way, my lord. The same thing, my lord. Admittedly, my lord, there is a encroachment, there is a gumti, and on which plot of land, whether it's land belongs to the private respondent, that is not reported here, my lord.
my representation will be considered by the subdivisional officer.
And my lord, at page 12 of the report, my lord, a FIR has also been lodged.
FIR for what? What is the cognizable offense?
My lord, the original written complaint of the
What is the offense?
against, my lord, Lordship may kindly come
What was the
to
complaint?
physical assault.
Physical assault.
Physical assault, my lord. Section.
Different cause of action.
That's a different cause of action, but my lord, if Lordship may kindly come to the very last page
Of the report.
of the report.
Yes.
The very last page, my lord, it comes to page 16.
Yes.
The page 15 is to the inspector in charge, Joynagar police station. Now, Lordship, if Lordship may kindly comes to page 16. First, second, third line from the bottom.
Sir, you are a very powerful person. Seems so. Seems you are a very powerful person.
I obtain all registration and
Show me.
state license. Yes, if you want,
Which plot? In which plot?
Plot number.
You don't know and you have got everything. That is why I am telling you. You must be a very powerful person. Must be a very powerful person. No, you're right about the property. That I want. This you can obtain. Trade license also you can obtain. Powerful persons can obtain. No difficulty on that. I want to see your right over the plot in question. Trade license, electricity connection, All these you will be getting.
And I filed a tax invoice from over.
That is what I'm saying. Municipal tax receipts, electricity connection.
And I have also registered my showroom to.
Yes, yes, yes. I want to see the your right over the property in question. Which plot you have set up this? Show me your right over that. That you don't have. Except that you have all other documents. That is why I think my observation was correct. You are a very powerful person. You have got everything except the right over the property.
But I last 3 decades, for half decades, I am running this business from my ancestor, my lord. And,
So,
uh,
so powerful person through generations.
but they are continually cheating me and trying to dispose of me from that from the shop. For that reason, I filed a writ petition before the Honorable Justice Shankar Ghosh, my lord. They asked
Police in action.
Yes, my lord. And he lost his right his order and direct him to file an opposition, but till date they are not filing the opposition.
My lord, complain and counter complain.
And he is a sole earning member
The
of
police
this
in action
family.
matter, the affidavits were directed. This shows what was there in your matter.
He is a sole earning member.
Usually, affidavits are not called for in police in action matters. Usually, normally, those are not called for. So, this shows the merit of that application. Ashun,
Kindly
the
admit that he is a
petitioners-
sole earning member of his family. If it is,
the petition
এসডিওকে জানিয়ে দাও হ্যাঁ এই কি করে জানাবে
Just
what
take your writ petition and other. Yes, call the next matter.
16, I beg to appear for the petitioner, my lord. The writ petition, my lord, as an order under section 10(3), my lord, one difficulty, my learned senior friend have handed over the opposition. There was a direction by your lordship.
Opposition?
Yes, my lord, your lordship kindly sees. There was a direction.
So you want to go through that?
My lord, I just now, we have to file an
reply.
exception also, yes, my lord.
Uh,
2-3 days time.
রেসপন্ডেন্ট তুমি আবার এ করবে
affidavit in opposition, Mr. Day, you are filing today?
Yes, my
Affidavit
lord.
in opposition filed by the yes. For all the reasons as aforesaid, accordingly the cancel Still.
Good.
Yes.
I have been inducted. Oh, sorry.
Inducted. Inducted where?
In the matter, I got briefed not 2 days back. I understand.
State.
Yes,
Yes. What is this matter?
your lordship was hearing this matter. It's two writ petitions are there. One I have the entire documents, the other one I don't. I'll tell your lordship, my lord. Here they are asking for, my lord,
Interest.
withdrawal of the money deposited by the tenant.
Interest. Withdrawal money is over. Only interest.
Interest part. Withdrawal is over.
Withdrawal is over.
So that is still pending. May I just show that part? If that is
What is
pending,
still pending?
the writ petition, it's still appearing in the list.
For interest only.
No. May I just say this? Not. That writ petition number 52, kindly, my lord, take.
Number?
Second matter.
52.
Exclusive for interest.
Kindly takes this one. Let's do, my lord, one by one.
52, yes.
Now this, my lord, 52, kindly, my lord, takes the prayer. I'll come to the petition later. This is, my lord, only with respect to crediting the amount laying with them in the account of the petitioner maintained by this to be directed to release the deposited rent amount of 1,70,000 within 60 days with interest. Yes. So this is only with respect to 20 challans, this writ petition.
52 of
No, I am reading the prayer of the 52. Just a second. Your petitioner prays that your lordship would be graciously pleased to direct the respondent to pay interest 12% on 9,43,000, which is already
That's the
remitted.
prayer. What you are reading is not the
It
prayer.
is the prayer. I have this copy.
What copy?
I do not know where I getting the copy.
You have supplied that copy. Please check up.
WPO 896. Sorry, 896. 896. 896.
I was talking about 896. You said 52.
No, 896. My mistake.
In fast matter, we have already
896 din. 896.
896.
Yes. So there were initially, my lord, 131 deposits.
Credit the amount laying with them in the account of the petitioner maintained and the petitioner respondent to be directed to release the deposited rent from the date of deposit till the date of remittance and such further order. Yes.
Yes. Now, with regard to this, my lord, I have twofold submission. One is that this 1,70,000 is only with respect to 20 challans, because kindly takes the petition once.
With regard to
20, there were total 131. He said, I got 111. That is an admitted position. 20 you have not given me.
So this is with regard to 20.
Now, this is with 20 and he has filed this in December 2025. Now, kindly, my lord, see two things. There was an order, page 8, Justice Sen's order, where 11 July 25, my lord, he was directed to apply. I will read those orders, but he was directed to apply for these 131. Subject to that application made in the correct form, my lord, I will release payment. Now, my instructions are, he had applied for 111. They were correct. I have scrutinized. I have paid. With regard to the balance 20, which is the claim in this petition, kindly, my lord, takes page
1,70,000.
1,70,000, the 20 challans. Kindly, my lord, takes page 33.
Yes.
I forgot to mention, this is from my learned friend's advocate. I forgot to mention particular of the 20 challans for withdrawal of the rent deposit by letter of 1st September, which was not shown in this compilation submitted on 12th August. The particulars of the challan are as follows. So then in 1st September, he says, in the earlier documents that I've submitted, that was only 111, 20, I forgot. So I'm giving you the challan now. Now, your lordship recalls, my lord, that this has to be done in a particular form. They have to give that form, which is what Justice Parthasarathi Sen's order is. Let me read that portion. Page 9.
Of this petition.
Yes, page 9, paragraph 7. Paragraph 6. It is submitted by Mr. Bashu Mollik. From the report, it would reveal, however, that it has been categorically indicated by the respondent number 2 authority that in order to get the deposited rent in his account, the writ petitioner has to comply with certain formalities as has been mentioned in page 4 of the report. It is submitted by Mr. Mollik. In the event the formalities have been mentioned in the report are complied, there cannot be any predicament on the part of the respondent number 2 authority to credit the entire deposited rent amount. After careful consideration, the entire materials as spread before this court and after hearing the learned advocate for the contending parties, this court, while disposing of the writ petition, grants liberty to the writ petitioner to submit the application for withdrawal of the rent before the respondent number 2 authority in accordance with the West Bengal premises tenancy rules, preferably by following the procedure as has been mentioned in page 4 of the report. Upon compliance of the formalities of the aforementioned rules, the respondent number 2 authority shall take appropriate steps for disbursement of the rent as deposited in his office to the writ petitioner. The entire exercise as indicated in the paragraph is to be completed within 120 working days from the date of communication. So interest I'm not dealing with now. So they were supposed to make an application pursuant to this order, which is July. They made an application in August, which is appearing from page 33. There they miss out, my lord, these 20 challan. But then those applications, I am told, were made in terms of the rules. There is a form which they have to fill.
Those 111?
111, yes. And I have scrutinized and I've got the entire records with me that we have paid. And it is undisputed we have paid.
Disputing.
Yes.
I don't know why his point is
I am
arguing because I am.
why? So we can end it.
All right.
Now these challans were then, my lord, missed out. Then what happened is, this I don't know why it's not there. He files this writ petition, but at the same time, my lord, those challans were ultimately in the perfect format given on 13th February 2026.
Which?
These 20 challans.
So this in a format they has given.
Later on.
Yes.
On 26. Then again that I have asked.
February 2026.
26.
Yes.
This is subsequent to the writ petition. So at the time when the writ petition was filed asking for this payment, my lord, there was no application, proper application before me.
So according to you, there is no inaction on your part.
No inaction with.
I am not entitled to get interest.
I am not on interest, sir. Let me just.
How hard to make it?
So with respect to the principal interest, I'll deal with later, my lord. There was no application before me. So there was nothing to disburse. When he made that application, I told him that there are two things missing also. Then board resolution is required. In the earlier tranche, he had given. But because, my lord, we have to scrutinize September, August, September, October, November, 5 months had passed. We again, that if your lordship turns over, we have asked for 2 documents. And
board
then
resolution and authorization.
Yes,
letter.
and that he has given after that, and he has given, and I have paid. But all this
You have paid.
Yes, 170 is also paid.
All right.
That is paid on 13th February. 25th February 2026.
I think that you have
I am
got
not.
that.
Yes. That is.
So now then nothing remains in this writ petition then.
Nothing,
You have got
nothing
that.
remains in this petition.
Why it has been kept pending? Only point is this: only 1,70,000 interest part has to be taken into consideration for that particular purpose that was kept pending.
Oh, yes.
Nothing else.
Interest part only.
Yes. Yes.
For that interest. Now, my lord, so this writ petition, the main claim, my lord, today is not there. At the same time, when the petition was filed also, it was premature because there was no application. So if there was no application, then the question of, my lord, also interest does not lie because as on the date of
till that date may not be, he is not entitled to interest for this balance period. But till you are withholding that amount
from the beginning. Very well. For that, my lord. And then for that, I'll make a composite submission. There is another writ petition which my learned friend has filed, which is for the entire 111 challans. This is 52. That is the other writ petition. This is 20 challan, interest. And here my learned friend is saying, I have already got 11 lakhs, 111 challans after that order of justice Sen. So now you give me 12% interest from that date. This is his case in both the two. Now, my lord, kindly takes Justice Sen's order once. If your lordship, my lord, goes to that order, the same prayer I am told, my lord, I am not told, I have seen, I have the previous petition. that was made there.
But not allowed.
Not allowed. And kindly see, my lord, at the tree, by filing the instant writ
I've seen
petition.
that together with interest.
So it was, he had claimed, and the writ petition, I have it with me today. And you compare the prayer, my lord, it's the same prayer. This is the writ petition. Na, kothay writ petition ta? Yes, 461. This. Kindly see the prayer in this writ petition and 52. prayer ta dekho to.
Yes. With
Same,
interest.
same prayer. And it was there on that date, my lord, the issue was there. He had claimed this amount before the learned judge and said, if you make a proper application, only then you will be entitled to this payment. And there was the question of interest, my lord, therefore stood rejected. At the same time, I don't find also, my lord, any legal right as such to get interest from, my lord, a quasi-judicial body. This, my lord, controller is a quasi-judicial body, my lord, formed under section 38 of this act, performing under 39 the functions of a civil court, civil judge, takes evidence, applies mind. If your lordship, my lord, sees that, there is no provision, my lord, that in fulfilling its duties as a quasi-judicial authority must be, my lord, liable to pay any interest. This interest today, my learned friend is claiming, there is no legal basis to claim that interest. No provision in law. This is like a premium he is claiming under the writ petition, which is, my lord, your lordship knows, my lord, cannot be permitted. Premium. 71 Supreme Court. Writ petition, you cannot come to court seeking any premium. Now, my lord, kindly seize the petition also once. I'll go to the law. No, before that, my lord, the facts. Kindly see the the petition. There is no pleading what his fundamental right is being violated. Nothing. No Article 21 violation, no 19 violation, no 14 violation. No. Joshua, Section 38 and 39. Appointment of controller. And 39 subsection 2. Controller shall have the same powers vested in a civil court under the CPC. So today anybody can go to a court saying you are giving me delayed judgment, give me interest.
Yes.
Number 2, my lord, there has the existence of a right is the foundation of a writ petition. Kindly, my lord, see the writ petition once. There has to be some breach of a fundamental right or a basis of a legal right. Kindly, my lord, takes the petition. Both petition, my lord, the same thing. Para 1, 2, Article 12. 2, he says who he is. 3 facts, 4, 5, 8 being aggrieved. Petitioner begs to move this honorable court on the following grounds. Even on the grounds, my lord, there is no violation of any fundamental right. 4 or 5 grounds. And the prayer. I am not sure, my lord, with the limited practice I have, whether this prayer is permissible.
Limited practice.
I thought, my lord, in writ petition, this is perhaps so.
Yes.
My first point is whether the previous one, first order, is a res judicata or not. That is also recorded in the previous order. I am saying on the citation. What is the constructive res judicata? This is judgment.
I have not cited
No,
any
the point has
judgment.
to
I
be
have
cited. We have raised the point that res judicata. That as on the first writ petition, interest I have claimed that has been refused. Whether refused or has not been adjudicated, that has to be looked into. That was recorded. My prayer, whether it was adjudicated or not, that has to be looked
no,
into.
first. But first of all, I want to say that he has to show he has a right. Then comes res judicata, on which I will, my lord, then cite decision. But first is the right. The foundation is not there. Kindly, my lord, learned friend will address your lordship on that first. Then, my lord, on merit.
You want to cite any decision on res judicata? You want to cite decisions res judicata, you can cite. Yes.
Yes. That is 2007 8 SCC 329 Saroj versus Kinuswamy, paragraph 4. What is the constructive res judicata means? Paragraph 4.
Paragraph 4.
First page.
Yes.
Before
is res judicata. Where is the constructive res judicata?
That is kindly come to para 4 subclause 4. The matter directly and substantially in issue or in the subsequent suit must have been heard and finally decided.
The explanations to section 11 has been considered here. Show me.
That is section 11 explanation. We have carefully.
The constructive res judicata is explanations to section 11, not section 11.
Yes,
Constructive res judicata is explanations to section 11. That's not the subject matter of dispute in that decision of the office.
When section 11 will apply.
So there is a distinction between section 11 and constructive res judicata.
Yes.
The decision may not be a res judicata, but constructive res judicata, it's within explanation. Decision is not did not consider those explanations. Not a decision on constructive res judicata. There is no dispute. So res judicata is issues raised, issues decided, that will be res judicata. Constructive res judicata is a different thing altogether. He has argued on constructive res judicata, not on res judicata.
All right. Even if assuming on the first occasion the interest element has not been decided or allowed, whatever may be, what is the subsequent for filing the next writ petition? Cause of action. It is a fresh cause of action. What is the fresh cause of action? Kindly come to my writ petition. That is second matter, 52.
First matter, what do you say? Let us proceed.
Because the second matter is actually covered up the interest. They have also.
But first matter, what are you saying? First matter is also interest.
In the second matter, whatever the findings will be.
Accepting that it's res judicata.
No, in the second matter, whatever the finding, that will applicable in the first matter also in respect of interest. In respect of, because second matter, everything is completed in respect of interest exclusively. Their opposition is also there. My pleading is exclusively for the interest only. In the first matter, there is some portion for principal amount, some portion for interest. So that would be better for deciding the issue of the interest. Second matter would be the best one, and that would be applicable in the first matter also. In the second matter, Kindly come to page number 15 of the writ petition. 15.
15.
The second matter, page number 50.
That is 52.
52. Page number 15. There is a letter from the rent controller to the petitioner.
Page 15.
115, 15. Addressing to the writ petitioner, referring to our above mentioned letter, that is the next, just the previous one. My letter is the previous one. I am coming. Letter. It is hereby clarified that this office has released an amount of rupees 9,43,500 towards rent payment direct strictly on the basis of the legitimacy provided under Section 21 and 23 WBPT Act 1997, read with Rule 11 of the WPT Rules 19. It is further stated that said Act and rules do not contain any provision for payment of interest on amount released as rent deposit. That is the fresh cause of action for filing this writ petition. In the first writ petition, there was no objection. Only on the recording that has been giving liberty to the petitioner, you approach to the authority, and if you apply it properly, that has to be considered within a period of certain time, 120 days or like this. Whether interest will be paid or not, that has not been adjudicated. No averment was there, no adjudication was there. The fresh cause of action filed for this when they have denied for making payment as there was no provision in the statute. That is the fresh cause of action. The fresh cause of action cannot come within the res judicata.
What is wrong in this?
That I will explain. That I will explain. That is the point. First is my letter. You have paid such and such amount. I claim interest. The previous one letter they have rejected on the ground. There is no provision in the statute. Now come to their opposition. What they have taken stand in 52.
In 52, yes.
In 52, their opposition. Affidavit in opposition. That point has been reiterated that there is no provision in the Act and the rules. And paragraph H. Page number 5.
Yes.
H. It is stated that due to administrative order by memo number such and such dated 30th January 2024, the rent controller office was shifted from its long-standing location at CBC City Civil Court building to the present office at the 6th Church Lane, Calcutta. For the purposes of hearing of the Honorable Commercial Court, Calcutta, during the process of shifting and transit, the substantial number of old records were damaged or lost, and certain waste papers were disposed of as per the official procedure by memo number such and such. Copies of the memo dated such and such is annexed here to and collectively marked as R1. Now come to the R1. R1 is the office circular. And page 2, the letter from the Deputy Secretary to Rent Controller. With reference to the subject mentioned above, the undersigned is directed to inform you the 3 lakhs forms which Rent Controller reported as Class C document as per records manual can be disposed following the practice and procedure as mentioned in manual before shifting the office of the new premises. If they are old forms, para 204 of the Bengal Records and Manual 1943 may be followed for disposal. Their contention is this: the whatever application documents along with them, that during shifting that has been lost. First of all, my case was that under section 21, 6, 7, 8 and 9 of the West Bengal Premises Tenancy Act, I am being a owner of the property, the landlord. I am entitled to get the application filed by the tenant in the rent controller office for permitting him to deposit rent. That has to be given to me. I am just referring the relevant provision. Kindly come to section 21, subsection 6. An application shall be accompanied by as many true copies thereof as there are landlords. How, as per the landlords, copy has to file. If there are 3 landlords, 3 additional copy has to file for each landlord at the time of filing application before the office of the rent controller. or persons claiming the rent along with the prescribed fee for sending such copy or copies to the landlord or such persons are registered post with acknowledgement due. No intimation, no application was provided to me till to date. That was my first point. Without my knowledge, without my consent, they have received, they have accepted from the day very beginning till to the termination of the or vacating the premises by the tenant up to 2025. They have kept going to kept money rent on my account without informing me. That was my first point. Second,
since when
2020-24.
Since when you did not receive the rent from the tenant directly?
2020-24, 2014, 2014.
2014.
2014.
So 2014, the money order was first sent to you. After you refused, there has to be a money order which was.
I do not know whether because
has to be
because until and unless the application that is the statutory provision.
That is the statutory.
That is the statutory provision.
Sir, that is the statutory provision. So since 2014, if you are not receiving the rent directly, because till 2014 you are receiving the rent directly, one fine morning from 1 month the tenant stopped you paying. But you did not take any steps. You did not inquire whether he was depositing, and you also did not take any steps because according to you he was in default. You did not take any steps. So
I am not. I am the landlord.
Also, you do not know whether the.
I am the landlord. I am not in default. I am the landlord.
I'm not saying you are the default. They were in default, and you did not take any steps.
Yes.
You did not. You chose not to take any steps. You also do not know whether the money order came or not.
Yes.
Yes.
Now, second point is this: on such deposit of the rent, the controller shall send in the prescribed manner the copy or copies of the application to the landlords. No copy have been supplied to me. Or persons claiming to be entitled the rate with an endorsement showing the date of deposit, such endorsement being authenticated by the seal of the office of the signature of the controller and some other officers authorized by him in this way, such authenticated copy of the application shall be admissible in. That means section 6, section 7 has not been complied with. Next, subsection 9. If an application is made for withdrawal, that is for landlord side, of any deposit of rent under section 23, the controller shall order the amount of the rent to be paid to him in the manner mentioned in that section and the rules made thereunder. Subsection 10, if any deposit of rent is not withdrawn by the landlord or by the person or persons entitled to receive the rent deposited, in case of deposit made under this act within 3 years from the date of posting of notice under subsection 7, that is most important. That is most important. That is clause 1. In case of deposit made under this act within 3 years from the date of posting of the notice made under subsection 7 or within 3 years from the date of commencement of the West Bengal premises stay, whichever is later. Next is not applicable in my case. It is for 1956. Shall deposit, such deposit shall be created to government as a lapse deposit.
I think credited. It should be credited.
Yes, that shall be credited to the government as lapse deposit. That means there is a specific provision. If I do not apply from the date of posting, this is most important. Within 3 years, the deposit shall be goes to the government account. On which date they have make entry? This is crucial question for determining the interest point.
Not a lapse deposit.
No, that is from this point is also very important. If they made entry as of today.
No, has it been a lapse deposit? It has not been
No,
a lapse deposit.
No, not.
So this
other meaning is there.
Deposit.
It is other meaning is there. Other meaning is what is the other meaning? If entry made today, if I do not withdraw the money within 3 years, that would be lapse. That means my time period is for 3 years. So now the rent controller is being remitted money. That means that entry has been made within 3 years. On which date they have made entry? On which date they have made entry? That is the crucial question.
I could not follow your submission.
Kindly come. In case, section 7, kindly come to subsection 7. Once again, on such deposit of rent, the controller sent in the prescribed manner the copy or copies of
that are followed. But you are saying when they have entered
in case
what provision?
Subsection 10.
Yes.
If any deposit of rent is
No, no,
not
subsection
withdrawn,
10, what is your submission on
submission is this: there is a system for posting. Until the posting is made, the landlord is not entitled to withdraw the money. And from the date of entry, if it is not within 3 years, then it will go to the government account. Am I clear now? That means the entry is the crucial point. If the entry is not made, the landlord is not entitled to withdraw money. If the 3 years is over, landlord is not entitled to withdraw money, because by this time, after 3 years, it has been lapsed. The question is, on which date they have made entry? Whether prior to 3 years, now they are remitting money. After filing successive 3 writ petition, I have got the money. And obviously, on which date they have make entry, posting in the ledger, kindly come to their my writ petition, page number 6.
Page 6.
Page 6. There is a compilation report of rent deposit and payment disburse.
Page 6 of the
52. Writ petition 52.
Yes.
6, page 6. 6. Annexed P5. This chart.
The writ petition.
No, sorry. It is affidavit in reply. Sorry. I am very sorry. Affidavit in reply.
Yes.
Page 6.
Yes.
Kindly see. September, then March, then June. There is a gapping. Tenant is depositing rent each and every month, but in the posting there is a gapping. April, May is missing. March 2014, then June. July, August, September, October, November, December is missing. That means there is a missing entry in their compilation sheet. This sheet has been prepared by the rent controller. On which date it has been printed out? 17th July 2025. Prior to that, I think 11th July 2025, there was a first writ petition order was passed. Only after that, they have made entry in their posting this as per section 21(7). Prior to that, they have not made any entry. And even that, when the entry was made, they have missed the challan and taken the stand. The bank has not credited the 20 challans, so I am not in a position to disburse those amount. You deduct out of 131 20 challans, and only application filed only 111. Those are as per compilation sheet. They are not taking that stand. They are not clearing that point. As per compilation sheet, they have only remitted the money. Those missing month has not been paid. Challan with me, but they have not paid. What their stand? The bank has not remitted the money. Then I filed the first writ petition as of today's list, including the 4 bank branches. You remit the money, otherwise I am not getting the money.
Yes.
That means first point is, as per the statute, until and unless entry is posting. Posting means that the ledger posting in their account, in my credit, yes, your amount is credited. Until and unless, that is the crucial date. From that date to 3 years is the time frame. If within this time frame I didn't withdraw the money, that will be treated as a lapse deposit. That means I am only within 3 months. Prior to that, I am not entitled. Prior to 3 years, I am not entitled. That means that only 3 years will be counted from the date of entry posting. On which date they have made the entry posting? As per their report, 17 July 2025. 17 July 2025. From this date, within 3 years, I am entitled to withdraw the money only in respect to this, as per this statement, 111 challans. I have withdrawn it. In respect of 20 missing month, what they have taken stand? No written communication, but verbally what they have taken stand? The bank has not credited those amount in your, so that I am not in a position. You pursue to the bank branches until and unless it is credited. What was my pleading in my first writ petition? 896. There is a specific pleading.
896.
Yes.
It is disposed of.
No, I am.
Yes.
Paragraph 5, page 4. Your petitioner states, Your Lordship got it. Page 4, para 5. Your petitioner states that upon making inquiry with the respondent number 2, that means rent controller office, it was learned that the amount of the said 20 challans are not credited by the respondent number 3 to 6, that means bank branches, in the account of the petitioner. As such, the amount is laying with them. With them means with the bank. So that I have filed the writ petition impleading the bank.
Yes.
That was specific government. What was the stand in their opposition in this writ petition? Nothing. Nothing. This paragraph, kindly see their opposition, how they have dealt with this paragraph number 5. Kindly see.
opposition.
896 opposition.
There is no opposition to that, which is why I showed those letters today.
Report.
Sorry.
Sorry.
Application was made in February 26.
Yes, report.
Yes, report. Kindly see how they have dealt with this paragraph number 4 in their report. There is no specific government. There is no specific government. That means if they have not specifically dealt with my government, obviously they have admitted.
Yes.
They are changing their stand from time to time. In respect of the 896, 542, in their opposition, they are specifically stated the documents comes within class 7 category and it has been disposed of as per the government order. On the last occasion, I have handed over the class C, under which category my application comes. Now, your Lordship directed to get instruction. Now, at first, he has to give reply whether that averment in the opposition supported by affidavit was a correct or incorrect. My application is actually destroyed, or it is taken a stand, a plea for not making payment of interest. Class C, kindly see, I have handed over the last occasion, the class C. এই চারটা দেখুন তো আছে কিনা রেকর্ডে, এই চারটা. Yes. There are 3 categories: class A, government record; class A, class B, and class C. They have taken the stand. The application comes within class C.
Yes.
Kindly see the class C, what category comes. All diaries except those already আপনার আগের দিনের এটা ফলো করা উচিত ছিল, ওনার সামনে হিয়ারিং হয়েছে ওটা. All diaries except those already noted under class B. The quarterly, half-yearly return, monthly return, returns, everything. What is that form? What is the application? 21 application is not covered within class C. So how it can be destroyed?
আরে বাবা নাড়াও না, রেপুটেশন এসব কিছু ওইটার গরু গাছে
On one hand, in their opposition in 52, they have taken the stand. We are not in a position to provide the form 52, that application section 21, because that has been destroyed as per office report. On which date? Now, after 2024, in their letter, they have mentioned it, the 2024, as per government order. Yes, page number 12, as per government order. That documents come within the class C. No GD entry. If the government record is destroyed, first of all, it is destroyed, or as per government order, it is just disposed of. If it is lost or in transit or in any way during the shifting of the office, there must be some GD entry. There is no GD entry. If it is as per government order, it is destroyed, then it must be on class C. That is also not there. That means in class C, my documents is not there. There is no GD entry. That means, as per the practice of the rent controller, they never supplied their form 21 application to me. That was the statutory provision.
Yes.
Now I will come why I am entitled to get interest. Fundamental right, everything, I have not pleaded everything, and now I will deal with it.
Yes.
কোথায় গেল জাজমেন্ট গুলো? This is the apex court judgment in 2020-25 7 SCC 269. In this judgment, all previous judgment has been taken note of. ছিল তো আর ছিল না, আচ্ছা দেখো তো এক্সট্রা আছে। In this judgment, all are the authority, government authority, statutory authority. The point was decided on numerous occasions, whether the petitioner is entitled to get interest or not. I have just relied upon 3 or 4 paragraphs, 16, 17, 20, 21, 22, 16 to 29. Kindly come to paragraph 16 first.
16.
1-6, yes. Is the page number 13. 1-3. Page number 13, 16. The concept of awarding interest on delayed payment has been explained by this court in case of authorized officer Karnataka Bank versus RMS Granite Private Limited and others in civil appeal number 12294 of 2024. We quote the following observation. It may be mentioned that there is a misconception about interest. Interest is not a penalty or punishment at all, but it is a normal accretion of capital. For example, if A had to pay B a certain amount, say 10 years ago, but offers the amount to him today, then he has pocketed the interest on the principal amount. Had A paid the amount to B 10 years ago, B would have invested that amount somewhere and earned interest thereon. But instead of that, A has kept the amount with himself and earned interest on it for this period. Hence, equity demands that A should not only pay back the principal amount, but also the interest thereon to B. That is also followed by other judgments also. Thus, when a person is deprived of paragraph 7 of use of his money to which he is legitimately entitled, he has a right to compensated for the deprivation of which may be called interest or compensation. Interest is paid for the deprivation of the use of money in general term, which has return or compensation for the use of the retention by a person of a sum of money belonging to other. Paragraph 20. In case of a secretary, this is a government body, Irrigation Department, Government of Odisha versus G.C. Roy, 1992, 1 SCC 508, a constitution bench of this court opined that a person deprived of use of money to which he is legitimately entitled has a right to be compensated for deprivation. Call it by any name. It may be called interest, compensation, or damages. This is also a principle of section 34 of the Code on Civil Procedure. Next paragraph. The essence of interest as held in the case of a Lord Reed versus Riches in Westminster Bank is that it is a payment which becomes due because of the creditor has not paid his money at the due date. It may be recorded either as representing the profit he might have made if he had the use of the money, or conversely, the loss is suffered because he had not the use. In case of a commissioner of income tax, that is also a government body, versus Dr. Shamlal Narula, a division bench of the High Court of Punjab authenticated the concept of principle as under. The words interest and compensation are sometimes used interchangeably, and on other occasions, they have distinct connotation. Interest is general terms in the return or compensation for use of or retention by one person of a sum of money belonging to or owned by another. It is narrow sense. Interest is sum of money. It in narrow sense is understood to mean the amount which one has contracted to pay for use of borrowed money. In whatever category interest in a particular case may be put, it is consideration paid either for the use of money or for forbearance in demanding it after it has fallen due, and thus it is charged for the use of the forbearance of money. In this sense, it is compensation awarded by law or fixed by parties, or permitted by custom or usage or use of money belonging to another, or for delay in paying money after it has become payable. Let's kindly come to paragraph 26. In Horichand versus State of UP, the Allahabad High Court, dealing with a similar controversy in stamp matter, held that payment of interest is a necessary corollary to the retention of money to the returned under order of the appellate or divisional authority. The High Court directed the state to pay interest 8% for the period the money was so retained, that is from the date of deposit till the date of actual payment refund. In case of ONGC Limited versus Commissioner of Customs, Mumbai, the facts were that the assessment order was passed by the Customs Act, creating huge demands were ultimately set aside by this court. However, during pendency of appeal, a sum of rupees was realized by OFA customs duties and interest thereon. In such circumstances, an application was filed before this court to direct the respondent to pay interest on the aforesaid amount with effect from the date of recovery till date of payment. The appellate relied upon the judgment in the case of Southeastern Coalfield Limited versus State of MP. This court explained the principle of restitution of the case of ONGC Limited. The appellant is a public sector undertaking, respondent is a central government, where we agree that in the principle as also in equity, the appellant is entitled to interest on the amount deposited on application of the principle of restitution. In fact, and in circumstances of this case, and particularly having regard to the fact that the amount paid by the appellant has already been refunded, we direct the amount deposited by the appellant shall carry interest at the rate of 6% per annum. Reference to this connotation may be made to the Pure Helium Indian Limited versus National Gas Commission. Next paragraph, paragraph 28. The compensation has been defined in P. Ramanatha as advance law. An act which is a court orders to be done, or money which a court orders to be paid by a person whose acts or omissions have caused loss or injury to another, in order that hereby the person dignified may receive equal value for his loss or be made whole in respect of his injury. The consideration or price of the privilege purchased something given to or obtained as an equivalent, the rendering of an equivalent in value or amount. An equivalent given for the property taken or for an injury done for another, the giving back to the equivalent in either money, which is but the measure of value, or in equal value otherwise conferred. A recompensate in value or recompense given for a thing received, recompense for the whole injury suffered, remuneration or satisfaction for injury or damage, for every description, remuneration or loss of time, necessary expenditure, and for payment, disability, if such be result, remuneration for injury directly and proximately caused by the breach of contract or due to remuneration wages. Last paragraph, most important. In the case of Union of India, through a Director of Income Tax versus Tata Chemicals Limited, kindly come to highlighted portion. Providing for payment of interest in case of refund amount paid as tax or deemed tax or advance tax is a mentioned now statutory adopted by fiscal legislation to ensure that the aforesaid amount of tax which has been duly paid in prescribed time and provisions in behalf from part of the recovery machinery provided in a taxing statute. Refund due and payable to the assessee is date weight and payable by the revenue. The government there being no express statutory provision for payment of interest. This is most important. There is also no payment provision for interest. The Supreme Court says the government, there being no express provision, statutory provision for payment of interest on the refund of excess amount or tax collected by the revenue, cannot charge off its apparent obligation to reimburse the deductor lawfully monies with the accrued interest for the period of undue retention of such monies. I am on 4 lines only. When that stand, there is no provision in the statute for making payment for delayed payment in case of interest. That is specifically dealt with by the Supreme Court. Even there is no provision, equity will apply. In this case also there is no provision.
What is the concept of payment of interest?
Concept of payment of interest, that those paragraphs is very clearly mentioned.
I'm asking you, what is the concept, object behind awarding interest?
Interest to compensate for retention of money, of my money in your hand. I have filed writ petition, then immediately I got the money. That means they are in a position to pay money, but they are not making payment because there was no direction upon them. Only filing writ petition, they immediately made posting, they made payment. That means until and unless I filed a writ petition, I would not get money. That cannot be the law. Everybody will come and file a writ petition for getting refund, for getting withdraw the rent, and then they will get the rent. That cannot be the law. And in their opposition or report, whatever maybe they have filed, that stand only 3 points. First, there is no statutory provision for making payment interest, so I am not obliged to pay interest. Number 2, you
will be entitled to interest from which date?
I am entitled from the date of deposit.
So, from the date of deposit, meaning thereby, have you made any calculation of any interest?
No, I have not made any calculation. If your lordship,
So, that is from 2014 itself.
Yes, 2014.
What will be the rate?
I think 12%. That is my claim.
That might be your claim. What is the law on this subject?
When regarding interest, there is no provision, so there is no scope of interest. But in those cases, all Supreme Court applied 12%. In the present case, this case are referred to separate cases. But in this case, what happened? 35 lakhs rupees he have purchased a stamp paper, and he has lost. He could not register his property. Subsequently, he again purchased 35 lakhs. And after that, he demanded from the government that I have lost documents, so that 35 lakhs with the government, so that should be refunded. Government, as per High Court's order, amount was refunded, but the government, stand of the government is this: the loss of documents or papers for his negligence, I have refunded the principal amount, but I am not liable to pay interest. Very interesting thing. High Court says yes. You have purchased 35 lakhs court fees, stamp, non-judicial stamp paper. Thereafter, you have lost. Now, you have got the principal amount. You are not happy with this. In your fault, you are claiming interest from the government. How it can be? The Supreme Court on a liberal side views taken, when the 35 lakhs rupees already in the government exchequer and government earn money from there for 3 or 4 years, why the government will not remit that money?
Rent controller is earning money from that.
Now the question is, yes, that is most important question. How in a month, how much amount is depositing rent in the rent controller? Say 1 crore rupees.
Rent controller is earning money from that.
Yes, I'm coming. Say in a month, 1 crore or 2 crore all over Calcutta, 1 crore rupees is depositing as a rent. Obviously, rent controller 1 crore rupees is not in a box. It must be in a bank account.
Income of the rent controller. Where from are you getting that?
Pardon?
That will be the income of the rent controller. Where from you are getting?
No, I have made party to the state government.
So, who has earned the interest?
Government, either government or other. I do not know from which account the amount is being taken care of. If the amount is remitted to the government exchequer, so obviously government is earning money. The government will compensate.
Not the rent controller.
Not rent controller. Not rent controller. That has to be disclosed them. That has to be disclosed by them, the rent controller. I am not.
You are claiming. You have to claim from whom? You have to. You cannot. Your claim has to be restricted to a person. You have to say yes. Such and such authority you pay, because you are the petitioner. Now let us suppose the state is not here. Nobody is appearing. So you have to make your.
My point
on
is
your own case.
Yes, my point is my amount is depositing in the account of the rent controller. Rent controller is liable to pay interest. First point. Now, if the rent controller is taken stand, the amount I am remitting to the state government exchequer, then the state government will be responsible. If that is point out by the rent controller. Otherwise, I will directly claim from the rent controller, because my amount is being remitted by the rent controller. In his account, my amount was laying for 10 years or 15 years, whatever may be. Huge amount. My case in only 12 lakhs rupees. Few crore rupees is earning, depositing rent controller. He is getting interest from there, and public are getting benefit of that. It cannot be. It cannot be legitimacy. My point is.
Anything more?
No, my lord.
Yes. What is your reply to these judgments?
Yes, if only that, my lord, I will respond, because other things, my lord, I kind of lost track. Today, my lord, my learned friend is asking for interest. And this judgment also says, yes, interest. But when an authority has been at fault or has...
You are at fault. You have showed these provisions, these subsections of section 21. You have not performed your duty. That's his allegation.
I have...
You have also not dealt with in that your opposition.
No.
Section 21, these subsections, your
6, 7, 8.
obligation, you have not performed that.
I had my obligation, Milord. May I just look at this? So these provisions and the obligations arising under this was the purview of the previous writ petition. When I did not do this, according to him, is 2014. And as your lordship pointed out, that he was not getting money from 2014.
Don't rely on those observations.
No, but which is a very practical approach, Milord. I think one must look at it that way. Milord, my learned friend was also sitting on his rights, assuming he had a right. And your lordship, Supreme Court also has said, I am not carrying those. That you cannot sit on your rights and come at a stage beyond the period of limitation. Even if I apply, Milord, the residuary article 3 years, assuming Milord 14, he knew that I am not getting any...
Payment has been made very recently.
So that I am coming.
After he approached.
No. After he approached, Justice Sense, our submission was that you have to apply to us. So his cause of action is only when he has applied to me.
So at that point of time, his claim was not rejected on the ground of delay and laches. At that point of time, he did not raise, no. You are no order can be passed on this. You have approached at a belated period. So Justice Sen passed an order, allowed them, gave them liberty to apply.
Gave them liberty to apply only.
Now, pursuant to that, they have applied. Then you have paid.
I have paid, but when that payment, as on that date, this argument was also made that I have not got 21, 6 not complied, 6, 7, whatever. I was basically...
Show me the provisions for withdrawal.
Yes.
That it has to be by that.
Kindly see first see 23.
Section 23.
Yes.
Yes.
If an application is made in the prescribed manner for withdrawal of any deposit of rent, the controller shall, if he is satisfied that the applicant is the person. So I have to satisfy myself that he is the person entitled to receive the rent deposited by order, direct the payment of the amount of the rent to him, provided that no such order for payment of any deposit of rent shall be made by the controller without giving all persons named by the tenant in his application for deposit of rent as claiming to be entitled to the payment of such rent an opportunity of being heard, and such order shall be without prejudice to the right of such person to receive such rent being decided by the court of a competent jurisdiction. Now kindly reads this with Rule 11.
I am at Rule 11.
Yes. Rule 11, Milord. Manner of withdrawal of deposit of rent. The application for withdrawal of rent deposited under 21 shall be filed in Form 4 by the landlord or by the person claiming to be entitled to the rent, either personally or through the agent duly authorized by power of attorney registered under the provisions of this Act, where the application for withdrawal of rent is filed personally by the landlord or by the person claiming to be entitled to the rent or to be duly authorized as aforesaid. Such landlord or person claiming to be entitled to the rent or duly authorized agent, as the case may be, shall get himself identified before the controller by producing his or her photo, etc. And then 3, payment of rent made to the applicant under the order of the controller shall be made in the manner provided in Form 4. Before passing an order for payment of deposited rent to the applicant, the original entry in the cash book and in the register of challans for deposit shall be traced, and necessary entry with reference to the payment voucher shall be made against the original entry in both the cash book and register for challans, so as to avoid entertainment of double or erroneous payment. Where any deposit of rent is credited to the government as a lapse deposit, we are not on lapse deposit. So this process got triggered for the first time subsequent to July 2025. When in August, Milord, they came to me, made an application. Even that application was not correct. So we told them that you go back, you come back with that proper form, you have to affix a particular stamp. I have all those documents. And all that, my lord, he did subsequently on 6th November 2025. So until then, there was no cause of action that I was retaining his money illegally, or he had applied, but I did not return, given him the money, my lord, which was deposited on his account. So when this process,
52 was for that 111 months.
yes,
52 was for 111 months, which the amount has been paid only interest.
Yes.
only interest, and the rest,
That is 52.
Yes.
And 896 is for 20 months.
Principal.
Amount, including interest, amount has been paid, now only the interest.
Yes,
Yes.
absolutely correct. Absolutely correct.
And this previous writ petition on the composite amount was claimed that I have not got. So on that day of the previous writ petition, they were under an assumption that I have given my challans. If your lordship sees that writ petition, what they did is they gave us the challans, saying the challans are deposited, you give me the money. They were under that presumption. So your lordship, on the when Justice Sen passed that order, we showed, we as in I take responsibility, because whoever was appearing for the state that day represented that you have given me the challans, but I am not liable to pay you until the time you make a proper application. You know, that is the procedure. So then your lordship said if there is no delay, there's no question of interest. So which is why the interest, my lord, was kind of deemed rejection in terms of, my lord,
Not
explanation.
say that when the since you have not applied, there is no interest. Where is that? There is,
That's deemed rejection. Explanation 5 to section 11. I am not without explanation 5 terminal. May I just read? CPC?
not expressly allowed shall be deemed to have been refused.
So
Okay,
the
that's the-
story goes like, yes, your lordship, my lord, knows this. My lord deals with this more on a regular basis than I.
No, I'm not dealing with those of them.
Yeah, I have also learned so much from your lordship. That one. Any relief claimed in the
Different branch now, so I'm not on that. Now our constitution, what else we proceed?
your lordship would do a lot of writ and constitution matters.
So now,
Now, yes, on this side also, which is long back, any relief claimed in the plaint which is not expressly granted by the decree shall, for the purposes of this section, be deemed to have been refused. Yes. And your lordship must consider that it may have been refused, or there was a deemed refusal because there was no application before the controller or the state authority to do the needful. Yes, perhaps if my learned friend had made an application and I sat over it, then perhaps he had a case. But without that, my lord, perhaps there is no case. And even then, my lord, I am an authority, like I showed, my lord, under section 39, where I have to scrutinize. So even if there is some delay in scrutinizing, which has not happened in this case, I am hypothetically speaking. Here, my lord, they came to me. Date of first withdrawal application was 6th November 2025, after the order of Justice Sen. And I have, my lord, paid.
hit those dates. Anything
Yes.
to his opposition.
6th November, opposition বলেছো কোথাও?
What dates, what you are saying, where is that?
Yes, kindly takes the opposition to 52 para C.
Position.
Para C. And my learned friend showed some paragraphs. Kindly also take para B. I have categorically said that there is no provision for payment of interest. And C, I have said, oh, pardon.
Position in 52. Yes, which paragraph?
C, page 4C. May I just read para 7 onwards once? Para 7A. In compliance.
Your opposition.
Yes. Page 3. In compliance with the order of 11th July 2025 passed by the Honorable Court, the withdrawal applications in respect of 111 months rent submitted by the petitioners filing number such and such dated 6th November 2025. So, were duly examined and processed upon compliance with the necessary formalities as laid down under the rules, and upon such verification, the payment amounting to rupees 9,53,000 was released on 17th November.
According to you, your obligation to release or yes, to release this money started on 6th of November 2025 upon their
Application.
submitting the application. So
Yes.
according to you, there was no delay on your.
There was no delay. And this was also considered in the previous order that there is no question of any interest because your application is not on board.
Was not decided.
Right? Deemed.
That's a different thing. You are saying it was said, it was not said.
Very well. I said deemed.
Deemed rejection is one thing. Deeming provision.
There was no application of mine to that extent what I am arguing.
Not decided.
Issue was
submitting that the principles of res judicata, if an issue is decided, raised and decided, then it's res judicata.
But yes, but explanation 5 says even if it's deemed rejection, that is also a barred between the same parties in a subsequent litigation. So I am coming through, my lord, explanation.
Anything more with regard?
Yes, anything more, yes. Now with the second tranche, they filed, my lord, on 13th February 2026, which I had shown. And then that payment was released on 25th.
That's where I was stated. You have stated here.
That happened, my lord, after that is 896 writ petition. So I could not state there because
you have filed a report there.
Report
dated 26th of February.
Okay, have you stated anything with regard to that? No.
Report is, I think, before. Report
payment made 25. Report later on. Prior to that payment made.
Now report down.
That report has not taken care of.
Yes.
But there is no affidavit. Lordship will take it from me. 13th February 26 they applied vis-a-vis the other writ petition for 20 months. And my lord, we have paid on 25th February 2026.
Those dates.
Yes. This is synopsis from the rent controller. Now once more, if
you have a copy of this.
Huh?
The original. Do you have a copy of
your lordship will keep it.
Please give a photocopy of this. Please give a copy to your learned friend.
Copy.
So please verify the dates whether it's correct or not.
The copy to
Their copy আছে?
Yes.
Now, if that is the case, then, my lord, the Supreme Court decision, which is, my lord, payment of compensation and interest for withholding of money belonging to somebody else illegally. That is not the case and therefore cannot apply. Kindly see these paragraphs, my lord, which my learned friend has relied upon.
Yes.
Lord, I have given my learned friend a copy. Para 16, quotation that is there is second line. For example, if A had to pay B a certain amount, then say 10 years ago, but he offers that amount today, he has pocketed the interest. Then 17, last line. Compensation for use or retention by a person of a money belonging to the other. I have not used or utilized any money not belonging to him or earned any interest. This I have stated in my opposition also to Milord that 52. Paragraph J. Everywhere it is that. Deprived. There is no deprivation in this case. It's a debtor-creditor situation where, my lord, it says that if I am your creditor and I have taken the money and not given you, my lord, I am liable to pay interest. Then para 29, which my learned friend specifically relied on because there was no provision for interest. He says it was allowed. There, my lord, excess tax was taken.
Assessment order, excess tax.
Excess tax. Excess tax collected, court says, of course, equity will come in and play.
Income Tax Act and those contains provisions while allowing refund also you have to, if there is a delay, you have to.
Yes, that
Yes,
is provision.
para Stamp Act also will have. This was a matter of.
Also, I think has some.
Yes, and
Yes.
has.
Yes, any other submission you want to make?
Yes. So this then will not on that score will not is not applicable. Kindly takes my in this contest my opposition once again will not paragraph page 5E.
Yes.
It may be noted that there is no provision either in West Bengal Presidency Act or rules providing for payment of interest amount released through rent controller. ওটা কোথায় যে I am not G. It is also submitted that no interest on rent deposited is enjoyed, retained, or utilized by the rent controller, Kolkata. Yes. And I am a custodian of that money. When he applies, he is supposed to get it back. Now, I have shown Milord, he has applied in 25 and Milord, I have immediately taken all steps, Milord, to give it back. And on Milord, non-compliance of 21.7, 21.6, etc. If I have there, if that is the case that I have not given him an application, there is no provision for payment of any interest for not giving him the application under 21.7.
But he was deprived from enjoying the money since you have failed to take those steps.
Not these money, what is being paid, Milord, is kindly takes 21.
Section 21.
Yes.
Yes.
Where the landlord does not accept any rent tendered by the tenant within the prescribed period, the tenant shall remit the rent to the landlord by postal money order within 15 days of such refusal. Now,
that's the obligation of the tenant, he has to do that.
Do that. Where the tenant remits the rent to the landlord postal money order within return.
Those are the procedures which are to be followed. When the tenant deposits, he has to file those applications. Those are to be forwarded to the landlord. He has to be given an opportunity. He has to be heard. Those are procedures with regard to.
Procedure, not a substantive right as far as that is concerned, my lord. Whether I must give him that, we could have asked for that application, my lord, if he was not getting, please RTI or anything, that please disclose whether you are getting any rent on this account or not. Nothing done. He sleeps over, assuming he has a right, my lord, for any procedure.
The rent controller holds the money on behalf of the land. That's the idea of this deposit of rent control. Since there's a dispute, the landlord is not receiving from the tenant in case of dispute. So if default, he may face a proceeding for eviction on the ground of default. To save him, to get protection, law enables him to deposit those before the rent control.
Yes.
So, and the landlord will get that amount in accordance with the provisions if he makes an application.
If he makes an application. And I bow down, my lord. That is the simple. Parallelly, under 7 also, your lordship knows, my lord. Assuming this process is not there, in section 7(1), 7(2), the money is deposited in the civil before the civil judge.
That's a different thing altogether. When they are proceeding, this rent control deposit is when there is no proceeding for eviction.
When there is no proceeding for eviction.
Section 7 starts with the expression on a suit instituted on any of the grounds under section 6. That's the starting sentence of section 7.
Yes,
So,
which is why it is before the civil judge, not
so
the
when a proceeding is instituted, then in order to get protection from
eviction.
you have to deposit before the civil court, not before the rent controller.
Correct.
So after that, those are invalid. You can withdraw that and deposit. So those
There also withdrawal application, my lord, also has to be made. Money is what I'm drawing.
to be withdrawn by the tenant, not by the landlord. He says that I have deposited wrongfully there. So he can get, he can withdraw, no adjustment from that.
Very well, we are deviating. What I want.
It does not travel that far.
Yes.
So you are not, this is not a landlord tenant dispute.
No, but it has coming to this. And number 3, most importantly, writ petition. My lord, kindly see the manner or the writ petition is framed, my lord.
Anything more?
And this order of justice sense, which is also the fulcrum, kindly, my lord.
According to you, yes, paid for interest, not awarded. And he was directed to apply in the prescribed form.
And my junior wants me to point out this part. Para 8, page 10.
Para 8, page 10. Yes.
Upon compliance of the formalities of the
Yes, yes. So if he complies with the formalities, then you have to disburse.
authority shall take for immediate disbursement as has been deposited in his office to the credit of the writ petitioner soon thereafter. As has been deposited. So this takes into the account that these deposits were made from
All right.
14.
Anything?
No. I think. My other junior wanted me to show section 20, 24.
24 of the Premises Sales and Normal.
Yes.
24 of the Premises Sales Act.
Yes.
What is there?
Under compulsion. Savings. Savings as to acceptance of it's not the withdrawal of rent deposit.
No. This is if he accepts. So then with regard to the correctness, it does not mean that he has accepted the correctness. That is the saving as to acceptance of it. It's an entirely different thing altogether. And it shall also not be a waiver to a notice to quit.
So just because he is withdrawing the money does not mean that he can't tomorrow come and evict him.
After all, the object is, it's after all his money. After all his money. That's his money. The tenant is not directly paying to the landlord. He is paying to the rent controller because of some dispute between the parties. After all, it's the money of the landlord.
Which he has got immediately upon making an application. That Milord, kindly last part is now making me a little.
Feel the pinch of that when your money will get stuck up there. Then you will understand.
And the last.
Otherwise not.
No. But I will not sleep over my rights, Milord. If I have a tenant who is supposed to pay me, and for Milord 10 years he is not paying me, I will not, Milord, if I may ask myself, look around. What is happening here?
How much time it takes for releasing of an amount lying in deposit of the rent controller? Do you have any practical idea?
Yes.
Do you have any practical idea?
They have applied on 6.
No,
I have not.
Pursuant to an order of the court. Under normal circumstances, do you have an idea how much time it takes?
I don't know, but this is not a
Have a
pub.
practical idea as to how these rents are deposited,
I haven't seen somebody.
apart from what is there in the rules.
They must, yeah, I understand, but it's not a public interest litigation. Vis-a-vis
It's a
this.
different thing altogether. But
There,
is-
those latches are everywhere.
that is, you do not know what is happening there.
Everywhere. Backlog in court also, my lord. We are knocking court's doors also, my lord. And the judges will now have to pay interest.
At least I have some.
Your lordship has, my lord, that matter is very quickly. Within 1 week, that judgment came in the other matter.
Not of judgment, of this, what is
Rent.
procedures, real practical procedures, not in black and white procedures.
No, I agree. Yes. But then we can't also open floodgates with, because this is a problem, my lord.
After all, it's the money of the landlord. After all, it's the money of the landlord.
In another matter, but this we will argue that point.
You can take instructions, you need
But
not
not on
submit.
this.
If your officers are here, how much time usually it takes? And what's the procedure going on?
Takes a long time. Must be.
Not only that, there are other which I cannot say it now. Yes.
No, but not this matter. This matter, my lord, I have satisfied your lordship.
Yes.
वीडियो नहीं तो off. So, my lord, we were discussing exactly.
The section 10 application under
For the petitioner.
Yes, madam.
Petitioner.
Yes, madam.
Because who is for this respondent?
Affidavit.
Yes, you are for the state.
All the time for the state.
Yes. Yes, yes. What is your allegation? What do you want?
Mother, just a second. Mala, this is under Moja Daspur, jail number 60, block Daspur 1, Mala, plot number 342, Mala. And it's been demarcated well with beams and boundaries.
Yes, what is your instruction?
No instruction has come as yet. And if you put up to 70,
The PWD road.
Yes, Mala, PWD road.
the executive engineer will at PWD make.
Assistant engineer is a party.
Yes,
Where is the representation?
At page number
30.
30, madam.
The petitioner claims to be
Report and under one silver, I am for the petitioner, your lordship.
yes.
Your lordship, I have served the copy to the state and other private respondent and executive engineer.
Yes.
And my given
State.
statement, I have served.
Now you are appearing.
And Kamal Misro. Kamal Misro.
Kamal Misro is for
Mala.
the private respondent.
No, Mala state.
Kamal Misro is for the state.
And Amit Gupta, Kamal Misro, my lord.
Yes. What do you want? What is the allegation?
My lord, the allegation is that, my lord, the private respondent number 7, my lord, made a construction in front of the sub room of the petitioner. My lord, petitioner is the owner of the property of short property, my lord. After making construction of sub room, medicine shop, my lord, the private respondent make a construction on the PWD road, my lord, totally obstructing the front side of the sub room, my lord. My representation is place 39.
If it's service filed in court 2 days taken
I'm for the petitioner. Milord, my ancestral property.
Yes.
I'm still in forcing possession, Milord, and that location.
Tenancy order has been passed.
Milord, page number 20.
Challenging tenancy order.
No, Milord. Milord, acquisition proceeding has been initiated under Act 2.
Acquisition proceeding.
Milord, acquisition was made under Act 2 of
93. এ ঠিক ফাইল দিলেন তো?
when encroachment, removal of encroachment hearing was conducting.
Compensation you want, but I find an order under 10.3. That is why I thought that this is an encroachment issue.
Mona, kindly see the prayer made in the declaration.
Yes, but the page 25, kindly come to page
45
25.
years delay. 45 years delay.
Page 25, please kindly come to 10.3 order has been passed. What for? Page 25.
Sorry. During removal of encroachment order by order passed by learned coordinate.
You are not challenging that.
I'm not challenging that, Milord. This is the first time I became to know that my ancestral property has been acquired in the year 1997-98 by the LA case number 79. But record is still in my favor, Milord, page number 14, Milord. Record of right is still in favor, and I am in complete
You are in possession.
Yes, Milord, I am in position. And surprisingly, location is that, Milord, from road, there is 10 feet of non-injury. After that, more than 80 feet distance from PWD road. How that land has been acquired by this authority? It is very surprising. Award has been passed. Award has been passed. Publication has been made, and because this suppress the material fact. Till date, we have.
He's an awardee.
Yes, his predecessor interesting.
Please give me that. This is the best case where it is to be dismissed with exemplary cost. Please give me that.
We have not received any notice. We have not. Kindly see. We have not received any compensation. Kindly see. Kindly see the notice.
One matter is to be
Page 11. Kindly see page 11. Monmotonath Mondal. Awardee number 26. Rupees 601.18. অবগত হইলাম Mondal. Sign. And my lord, what is the reason? Can you see page 1? Award number 26, Monmotonath Mondal, 5 share, 681. Award number 27. The award remarks the Monmotonath disease and no legal heir certificate was ever produced. Consequently, payment of 601.68 was not released and marked as stopped the award register.
Sir, how much cost you are willing to pay? I leave it to you.
Milord, we have not received any notice.
Yes. How much cost? That is what I am asking you. How much cost you are willing to pay?
All notice has been issued.
Very easy to say that I have not received. Coming after 45 years, very easy to say. How much cost you are willing to pay? I leave it to you.
Milord,
Otherwise, if you leave it to the court, it will be a difficult thing then.
Milord, record of right is still in my name, Milord. And
Sir,
I am in
I have asked you. You know very well the record of rights. What is the effect of those recording on the record of rights?
Kindly allow us the report, Milord.
What report?
That compensation.
No report they will give. They will not give any report.
Then how we people become to know that?
It will be in the order. I will reflect that in the order.
This is the first time in.
When your predecessor died?
In the year 1980. No,
53 years. 59.
In the year 59, Milord.
1959.
1959. 25th June 1959.
Who died on 25th June 1959?
Monmotonath Mondal.
No, Sudhir, when Sudhir died?
Sudhir died on 14th February 2002. Sudhir. Sudhir also signed. Sudhir Mondal. Same plot. Same plot. Nowadays it's very easy.
Munmoto's heirs have not come. Sudhir's heirs and Shamapodo's heirs have come. When Sudhir died,
Milord, his father died in the year 1992.
Sudhir Mondal.
Sudhir Kamala Mondal, son Sudhir. Milord, that statement not with me, Milord. But we are the legal heirs of the Monmouth Mondal, Milord.
You are the legal heirs of Monmouth Mondal.
Yes.
You are the legal heirs of Sudhir Mondal. Deepak Mondal, Mrityunjay, Dhananjay are the heirs of Sudhir Mondal.
Milord, Kalipada Mondal, Pita Monmouth Mondal, Milord, page number 14.
See your cost title. I'm here at your cost title. Writ petition cost title. First page.
Let's Sudhir Mondal.
1, 2, 3 are sons of let Sudhir Mondal. 4, 5, 6 are sons of let Sham Mondal. So, when they died?
Sam Mondal died in the year 1992.
And Sudhir?
Sudhir statement not with me, Milord.
And this acquisition was in which year?
1970, 77, 78.
So, you are not born on that day even. What was your age on that date? The person who is affirming the affidavit?
To his knowledge.
Now 64 years.
Yes.
And
what was his age in 76, 77?
Minor.
Minor. What was his age?
25, 30 চলে গেলে so 70 not born.
How do you know that your predecessors did not receive compensation? Where is that statement? Your acquisition of knowledge, from whom you have come to know? Because notice will not be served to you.
Milord, RTI was submitted by the petitioner.
I'm asking you, notice will not be served to you at that point of time. Your predecessors were all living. How do you come to know that compensation was not paid?
Milord, I submitted RTI application before the authority. Page
Yes.
number 26, Milord.
Page
26.
Yes. What is the reply?
Applicant is requested to apply to the special LOA Purbo Medinipur.
Yes.
But
rightly.
No such answer of.
So you have given her to the block land and land reforms officer. He is not the authority. And special land acquisition officer has given you this information 76, 77. This acquisition proceeding was made.
Accordingly, Milord, I have submitted my representation for
the Next. Yes. Yes.
I am appearing for the petitioner lordship. In front of my land, on PWD road lordship, the private respondents have
Unauthorized construction. Yes, private respondent served.
they have been served.
You are for the private respondent. Yes. What is the instruction?
My lord, as per the instruction, I mean instructed that the disputing property, which they are telling that I am encroaching, I am making unauthorized construction, I am not residing at that property.
You are not residing?
No, not over there.
You are over where? What is your plot number where you have constructed?
My lord, in that case, my lord, I have to take the documents, my lord.
Ashun. Yes, Mr. Dev, what is the instruction? 30. PWD
I
road.
am deciding there for last 40 years.
PWD road. The petition. You submit as expeditiously as possible. লিখে দিন yes
Lordship kindly fix the proper time.
fixed আছে না একটা Fixed আছে।
Your Lordship has fixed the proper time. For consideration of the representation, your Lordship has fixed the proper time for the
As expeditiously I have said, because you have to file a representation. Please submit that representation. Yes. Yes. Yes.
Thank you.
না হবে আমি একটা কোন ধরে
On the last day where I paused, kindly will not come to that page first. The
Supplementary affidavit, my lord, affirmed on 19 January 2026.
Yes.
My lord, text, my lord, page 6, annexure P10. My lord, first paragraph, which I was reading, my lord, kindly takes, my lord, last 4 lines, my lord, where I had stopped. For the purpose of, Lordship has seen, my lord, for the purpose of setting up of a township
and a school
on 2 acres, and subject to the condition that the existing school lying within the premises should be rehabilitated in equal area within the project area. So, my lord, this letter itself speaks for that there would be 2 schools, one already existing school and one school to be set up. Kindly, my lord, read in between the lines. 15 acres for this project and 2 acres for the school, and existing schools, and subject to the condition that the existing school lying within the premises should be rehabilitated in equal area within the project area.
You are that existing school. You are that existing school.
Well, my school.
You are the existing school.
Well, may I say, in my way, I am not only an existing school in that area, which comprise also Dag number 134, but being recognized by the government of West Bengal and 100% aided. And upon the promises and assurances being made by the government of West Bengal, I have also altered my position. I run and enhance to higher secondary with a collective decisions of inter-se departments to promote me in terms of the rule, whereupon now the secondary education also requires physical education, some sports activities, which ostensibly for a requirement a ground. And I have referred on the other day, yesterday, today also, I would refer that the Central Act for imparting education to the children, whereupon the government also reconsiders that in a metropolis that there may be a shortage of area. Now, how it could be accommodated. And here, in this page 6, another interesting part. Now, if they say that there are other existing schools than me, that is also a part of a decision-making process which are impugned. To be out of extreme fairness, Lordship knows,
I have nothing to hide and suppress. Unless I being very fair and honest, I cannot also express no any equitable relief. Today, if they stand on equity, I also stand on equity. Now, my lord, there is also another school, according to my instruction, some my lord, Azad school, something. Maulana Azad, which is a private school. Now, my lord, how the government has so much sympathy and creating a class within a class, being not recognized a government school than of a private school. And here,
Mr. Basu, those are, please don't travel beyond the scope. Please don't travel beyond
I'm
education, what education, government making class within a class. Those are whether you are recognized, whether you are not recognized. Please limit your argument within the scope of this petition. Please don't expand it unnecessarily.
I am with my.
If you expand it, you can expand it to any. Please don't do that. Please limit your argument within the scope of this petition.
My lord. Now, my lord, my scope of this writ petition is to, my lord, the decision-making process of the state respondents in not giving me the land. That is my plain and simple case.
Kindly come to that. Grant in aid, 100% aid. Please don't go to that.
Now, my lord, as your lordship has, my lord, has been pleased to observe, my lord kindly takes up my lord, that document once again once again, my lord. My lord, the paragraph 6, my lord, on the said page.
Mr. Basu, please formulate your points.
My lord.
Thereafter, please formulate your points.
My lord, my points, my lord, firstly.
Yes.
As my lord, my learned senior friend, my lord, Mr. Mujumdar has pointed out, and my lord, I have to answer that whether my lord can receive this petition and adjudicate in its present form and manner, subject to my lord, other my lords, specified statutes.
Yes. Yes.
Secondly, my lord,
yes,
whether my case or the petitioner's case relates to, my lord, our decision-making process in regard to, my lord, non-grant of the adjoining land, despite of, my lord, specific and positive assurances and promises.
Yes. Next.
Lordship may kindly also add that including the reconnaissance surveys.
Those are on. You will
Well, very well, but incidental parts. Well, thirdly, my lord, whether, my lord, upon such promises and assurances, I have altered my position based on such steps being taken, and whether there is a promissory estoppel, my lord, in this regard, and the state can, my lord, subsequently, my lord, alter its stance. My lord, fourthly, my lord, I would try to, my lord, argue also on that point, but I need, my lord, some more informations, hopefully, my lord, that whether, my lord, they at all.
You have not yet received full.
No, I have received full instruction. Very well, my lord. I'm not saying that. But the fourth point is this: that if my lord takes up my writ petition,
I will take up. Please formulate your points first. Thereafter, I will go to those.
My lord, my fourth point is this, my lord, that whether the state my lord is obliged for my lord the logical conclusion of the departmental processes and initiatives that being taken place for the grant of or my lord, upgradation of higher secondary to the petitioner school.
Yes. First, kindly come to the maintainability issue.
My lord.
What is the order which you are challenging?
My lord, to me, there is no order.
What decision you are challenging? What is the act which you are challenging?
My lord, to my lord answer, my lord, I have already shown that page. The page 6 of the supplement.
Yes.
And my lord, I had already referred. I do not wish to multiply or reiterate. Section 6 of the specified act that there has to be an order.
Section 6 of the specified act, there has to be an
order
that you have submitted.
Yes.
Yes.
My lord, Land Reforms Tenancy Tribunal Act, Section 6.
Order, so writ petition can be moved.
My lord, if it does not fall within the ambit of Section 6.
Yes. So if there is no order by any authority under the 1955 Act, so it does not fall within the jurisdiction of the tribunal.
My lord, any
If it does
order,
not fall within the jurisdiction of the tribunal, writ is maintainable.
my lord, this is what the statute says. I have to make out my case, my lord, within that statute.
Yes.
My lord, in addition to this, my lord, the tribunal constituted under Article 323B, my lord, having powers only to the extent, my lord, that the statute provides. It cannot go beyond that. My issues before your lordship, my lord, something different. My lord is sitting, my lord, under Article 226. It's a superlative, my lord, unbridled power, my lord, having, my lord, no dimensions, having no boundary. My lord, today, my lord, I am
appearing for that side. You will be saying that.
At that time, with your lordship's blessings, my lord, I may also take this point. Lordship knows, my lord, our duty is often, my lord, being changed. Now, my lord, that would be my another point, my lord, that I would try to formulate and persuade your lordship, my lord, that with a limited scope and for a limited purpose, and there cannot be any piecemeal adjudication. Even for the assuming but on admitting, the some part may even hit. Some part. Though I say, my lord, it doesn't.
According to you, there is no order, so nothing can go before the tribunal.
Exactly. And there is also not a case of any culpable inaction, because action has already been taken in other way around by giving a grant. Now, I have nothing botheration, but I have no botheration with regard to the grant. I am only concerned with my land. Now, these 6 subsection A, B, C, D, E, at best, my lord, this A and B could be argued against me by any authority order. And I say the order has to be, my lord, upon an adjudication of a lease between the parties.
Yes.
Now, my lord, here, why I have
you are not challenging any order. So
I am not challenging, but there is no order. That is what I am trying to show.
Yes.
That's what I am trying to
Because
show.
there is no order passed by an authority.
No, because I am trying to, my lord, develop my case from the document itself, my lord, which was given to them. Kindly see page 6 once again, serial 6. This is not an order passed by the prescribed authority, the DLRO or something like this. He is merely communicating a decision. Kindly see, my lord, is approval rather than approval. Kindly takes up serial 6 of that page 6. These issues with due approval of standing committee of the cabinet on industry, infrastructure and enterprises in his 5th meeting held on such and such. Now, my lord, as I've indicated, my lord, one of the major portion of my case would depend upon a promissory estoppel, which can only amenable in a judicial review in 226. The tribunal has no power. Tribunal cannot even look into it. The statute doesn't provide him with such power. Well, keeping even in L. Chandra Kumar, well, that L. Chandra Kumar strictly says that that tribunal can only look into if something happens within the ambit and scope of that power only. And thereupon, my lord, there are other judgments also concerning land reforms tribunal, or she was aware also, my lord, that Ashish Kumar Rai and etc. others, my lord, they may also try to show, my lord, that judgment even. Now, there is here, my lord, my case is based upon non-grant and promissory estoppel. And, my lord, a judicial review of the entire decision, coupled with facts that the 2 schools are being set to run, where my situations being prejudiced and deprived. And today,
so you want implementation of this page 6?
I'm not implement. I do not even know. I'm not even seeking for implementation. I only seek, my lord, implementation of the assurances and promises that being made.
Placing this page 6.
No, I am placing, my lord, in order to, my lord, have a, my lord's wisdom to, my lord, to do a judicial review that a government school is being denied.
Not now even follow what is your challenge. That's the difficulty. Please kindly come straight away to that. Thereafter, I can vouch this. So I thought that you are trying to implement this. What are you trying to canvass? Please show me from the writ petition. What are you challenging? What is your prayer? What do you want?
My lord,
what is the basis of your claim for that?
My lord, I have followed.
Because you know your case better, because I am looking at it for the first time. So that's why I have to understand
No,
the scope of
my lord knows, my lord, much better than from all of us. I could not say about Mr. Chakraborty.
Vasu, I'm looking it for the first time. So please, idea about the scope of the transaction.
My lord, may kindly comes to my writ petition. Page 49 of the writ petition.
Yes. Yes.
My lord, kindly, my lord, mark this letter 12/3/2019.
Yes.
Issued from the Land Reforms Department, Assistant Secretary to the DLRO, that with reference to your memo dated 7/2/2019 on the subject mentioned above, I am directed to request you to let this department know the status of the land at present, and also to offer your views if the land in question can be resumed.
So this is the basis of your claim. This is the basis of your claim that you applied, you prayed for 1 acre settlement of 1 acre of land adjacent to your school building. So, pursuant to your
in view of, in view of, the
I will come to that. Please let me understand this letter. So, from this letter, what I get, that you've made a prayer for settlement of 1 acre of land adjacent to your school building for extension of your school building.
No, No, my lord, I put it in other way. I did not, I say, my lord, kindly provide me that land. I do not use,
The subject says prayer of Badartala Madhyamik. You are Badartala Madhyamik
yes,
Balika
my lord,
Vidyalaya.
this is how
What
they
section?
write. This is how they
What is
write.
your letter of the prayer?
My lord, kindly takes, my lord.
Page 42 also. Page 45 also.
You have annexed your prayer.
Yes, yes. I have
What is that? Which
Page 42 also.
letter? Which page?
Kindly comes to, my lord, page 40.
40. Yes.
That's it.
If you, my lord, kindly comes to the last two paragraphs at 41.
Yes. So this is the letter. So
and this is with regard to prayer for getting 1 acre land.
yes, not for settlement, for getting 1 acre near about 1 acre from backside of our school for extension. So this is your prayer. So pursuant to that prayer, the assistant secretary is writing to the ADM at page 49.
Page 44 I write to the Land Reforms Commissioner. Secretary.
My lord, may also comes to page 44.
Yes.
Which was also a prior letter, my lord.
Yes.
18417.
Yes. So you have written to the Land Reforms Commissioner that there is an unused portion of our land for a long time. So you want to get that land for further extension.
Yes.
So pursuant to these letters is the letter at page 49.
No, there are other various communications. Kindly see page 45.
Page 45.
Yes. Yes, pursuant to a prayer, Mr. Basu.
Yes.
The thing is that you wanted, if I can put it in your language, you wanted to get 1 acre of land adjacent to your school building for extension of that.
Which, my lord, I have been using and possessing.
Yes, yes. So you are using, possessing adjacent land. So you want to get that land for the school for your extension purposes. So in consideration of that, page 49 is the letter.
And in the meantime, my lord, the government, in considering, my lord, and a process of granting.
Yes, yes. So page 49 is the letter of 12th of March 2019. So the assistant secretary writes to ADM LRO that he wanted to inquire about the status of the land.
Now kindly takes up
then what
next
happened?
Next page.
Yes.
Government has decided to conduct a reconnaissance survey.
Yes. So after that, a survey was made.
Yes.
Yes. Then
47 also.
47.
Kindly checks, my lord, page
47.
47.
Yes.
Inquiry report as per rule 166 of the WPR.
My lord,
my lord.
13th.
No, 13th কিছু হচ্ছে না।
13th. Why?
13 there will be nothing. 13 court will operate. No resolution being adopted.
13th. I'm fixing this matter on 10:30.
Yes.
But 13 I will not be here.
Will not be there.
Truncate holiday, truncate day. Truncate day, my lord.
Tomorrow, my lord, tomorrow.
Otherwise,
conclude.
Mr. Chakraborty doesn't, my lord, remain present. But here, my lord, you will be present.
No, Lord, let
And
us
only for
understand.
this matter, Mr. Chakraborty, even on VC mode, my lord, he would join.
It's not that, not we have a duty not to, my lord, continue with one matter, my lord, for a long time.
Then
Let
you
us
can
finish it. Let us
When your
finish it.
lordship feels, my lord, but to be very honest, my lord, the lordship accommodates me some time.
How much time?
But I understand, my lord, I am only trying to be satisfy your lordship on the maintainability. I know, my lord, lordship has what is, my lord,
If
concern.
you want me not to take up this matter, I can release that.
Have I
That's,
ever,
preferential,
even on my imagination, I could not even thought
that's
for.
pure and
No, I am
simple.
only, my lord, being my lord's officer. I have been trying to impress upon your lordship, my lord, this is maintainable. And with my small
When do you
legal
want
acumen,
to come back?
would it be, my lord, proper for me, my lord, to seek, my lord, some
Don't
time
say
for
anything which is not improper on your part.
no,
If you think it's not improper, it's not proper, please don't make that submission.
no, my lord, put it after a fortnight.
Not I,
For
Fortnight, he will not be here.
no, just to, my lord, have this finally settled, my lord.
Mr. Basu, please tell me frankly, if you are not ready with this matter, please tell me frankly.
13 January, we made the submission. Today we are in the month of April.
Matter is continuing for a submission.
3 months time
Now,
he
if
got.
you say that you are not ready,
No, I am ready, my
13
lord.
January.
No, I do not say, my lord,
Unfortunate then.
my lord, I do not say that I am not ready. But I
For 2 weeks, what will be doing?
very well, my lord, very well, I leave it. Well,
Just come
I
back on-
need some more, my lord, answer for my satisfaction so that I can also satisfy.
Till now, you are not satisfied. If you are till now not satisfied, it's very difficult.
Well, I leave it to you.
Maybe come back on 6th.
Well, I do not wish to embarrass.
When do you want?
Whenever. Well, I prayed. Now, yeah, it's up to your lordship. I do not wish to embarrass, my lord. I do never.
13th he is not.
17 is difficult because on those 2 dates,
Not at 4 p.m.
16, 17, there's a larger bench. 17
Oh,
is a
acha.
division.
The 13 January, the point was taken. You have taken 3 months time again. You please conclude this. The client is suffering. They have to pay the seniors fees. Mr. Mujumdar is
Client
there.
also suffering for this.
Mr. Mujumdar is there.
Wants the allotment of the land.
Exactly.
Whatever way, let
Our
the court
suffering is
decide
much
it.
bigger.
Then
The court
it
decide
does
that.
not seem so.
Well, they are the business
You are trying
tycoon.
to expand this
Let us
matter and
not speak, my lord, either here and there.
that your client is willing
I
to
re-
take this land.
Not
Does not seem
20th at
that you are in
10:30.
urgency.
Not 20th at 10:30. Let him conclude. Or not sometime so that he could conclude.
9:30.
No, I believe that joke is not going on. Mr. Basu has realized not the sincerity, seriousness of the situation.
Please give me the time when you want to.
Seriousness of the situation, we should
Whenever
appreciate.
it commences to your lordship. My lord, I prayed for a certain thing. If you're now up to your lordship,
Please consider this matter is going for a sufficient
Fine, I understand.
long
I
time.
understand. I
I
understand.
will forget. Then
I
it will
understand.
take some 5-10
I-
minutes to recapitulate.
I understand. I understand.
That is why I'm fixing it.
Well, that is why my lordship knows, my lord, I never wish to, but I do not even. My lord, I want to be, my lord, more, my lord, satisfied for myself, my lord, because since this point, my lord, it is my duty to satisfy your lordship. This is my being my lord's office.
You want 2 weeks to get yourself prepared.
Not kindly. Not kindly. Not kindly.
Well,
Not
two
we are
weeks
suffering. Lord, we are suffering. Not kindly, we are suffering. 13th January, we took the point.
Chakraborty, he is not ready now.
13th January, today we are on almost 13th of April, 3 months.
Prepared. What can we
3 months, Mr. Basu, it will take 5 minutes for him. But 13th January, we took the point. It's a question of law. Only pages are being shown. But we are suffering every day. I never opposed like this, but this is a difficulty. I am compelled to do this.
But whenever your lordship puts up on it, even before 2 weeks, my lord, I do not.
fixed at 4 p.m.
Not me, I beseech your lordship. Kindly keep it at 3:30 so that it could be, Mr. Basu could conclude on that day. Because 4 to 4:30, half an hour, Lord, it's too short for him.
Not be completed.
Too short for him.
My lord, 20th and 21st.
Obviously. He would have some
My lord,
difficulty.
kindly keep it some other time.
Yes.
4 p.m., my lord,
That is what I am asking.
4 p.m. he has.
Yeah, date. You are not giving the date.
My lord, I say, my lord,
No, 2
fortnight, my
p.m.
lord,
keeps,
kindly keep it on 27.
keeps it on 2 p.m. He has difficulty at 4 p.m. Keeps at 2 p.m. on 20th. But kindly consider our predicament, Lord. I can't disturb the court's proceeding like this. Well, let us finish this matter.
How much time, Mr. Basu, will be taking?
My lord, 40 minutes.
3 days back, 40 minutes.
The maintainability.
I recollect 3 days back, 40 minutes he sought.
Mr. Basu, be reasonable to the court also.
Hey, Judge Sahib, to no
Do not be to your other side.
Hey, Baba.
Be reasonable to the court also.
My lord.
No, 13th he has difficulty, 16th, 17th, your lordships have larger bench, 20th, not at 2 p.m. Not, let us finish it. No, at 4 p.m. he has difficulty. He said at 4 p.m. He said at 4 p.m. he has difficulty.
My lord, 4 p.m. onwards, I have difficulty.
How much time it will go on? Up to 4:30. After 4:30.
My lord, I have, well, I couldn't even say, my lord, that there are some other preoccupational issues, my lord, and there.
Let us come back a little early at 2 p.m. Lord, kindly accommodate, kindly finish this matter. Lord, whatever way you lordship.
27, kindly keep
Lord,
it on.
not 20th. Lord, I beg to oppose this.
At what time?
Anytime.
10:30.
Anytime.
Let it be done. Let it be done on that word.
Release this matter. Mr. Chakraborty, if you do that, I will.
I'm sorry. Whenever your lordship fixes me, Lord, what can I say?
7th of April, fixed at 4 p.m.